that you're welcome to use your mobile devices as long as they're in airplane mode and all devices are muted. This includes members' tablet devices. They can connect to this. Also to remind members that we are obliged to declare any financial or other relevant interests which might be reasonably thought by others to influence our approach to the matter under consideration. Any members who have interests to declare in relation to today's business should do so on or when the particular matter arises during the meeting. Just seeking the members' agreement for the oral evidence session on the Justice of Sex Offences and Trafficking Victims Bill and the June monitoring round to be recorded by Hansel.
Great.
Item 1, apologies. We have an apology from Sinead, the Deputy Chair, from Emma Rogan. Also, Doug has sent us a wee note to say that he will be joining us later, and Gemma and Rachel and Sinead are joining us by Starley. Just in regards to indicating that those members who have delegated their authority to vote on their behalf as provided for by Standing Order 1156, the Deputy Chair, Sinead and Emma have delegated their votes to Gemma Dolan. Agenda item 2, the draft minutes of the meeting held on the 9th of December 2021. There are pages 5 to 16 of the meeting pack. And are you content that these minutes are a true reflection of the proceedings held on the 9th of December 2021? Agreed? Thank you. Item 3, matters arising, and there are just a few items, members, that we want to briefly go through with your indulgence. Item 1, the response from the Department of Justice on the review of the Probation Board status and governance. The response has been received from the Department advising that in light of the feedback from the Committee, it now intends to undertake a full public consultation on proposed changes to the governance arrangements for the Probation Board. Consultation was launched on the 8th of December and will run for 10 weeks. The relevant correspondence is at pages 18 to 20 of the meeting pack. And this is just for members to note, unless there's any further clarification. So, item 2, the Justice, Sexual Offences and Trafficking Victims Bill, and that's further information from Women's Aid following on from the oral evidence. Women's Aid had provided additional information in relation to Part 2 of the Justice Bill, which covers the trafficking and exploitation following the oral evidence session on the 2nd of December. The relevant information can be found at page 4 of the table pack, and it's for members to note the additional information which will be added to the electronic bill folder and the bill web page. Item 3 is correspondence from KRNI regarding the report stage of the Nationality and Borders Bill. KRNI has written to the Committee regarding the report stage of the Nationality and Borders Bill, which took place in the House of Commons on the 8th of December 2021. The position regarding longer term support for confirmed victims of modern slavery. Relevant correspondence can be found at page 5 of the table pack. KRNI has underlined the potential for Northern Ireland to support victims of modern slavery through the inclusion of their proposed amendment, Justice, Sexual Offences and Trafficking Bill, to extend the current discretionary support to 12 months statutory support. And is to ask members to note the correspondence unless there's any other information that is required, and it will be added to the electronic bill folder and published on the Committee's website. There will also be an opportunity, members, to discuss CARE's proposals as part of the deliberations of the bill after Christmas. Item 4 is the Justice, Sexual Offences and Trafficking Victims Bill Part 1, and we will have the officials. This will cover Part 1, Part 3 and Part 4 in terms of the oral evidence. And departmental officials will attend the meeting today via Starleaf to discuss the key issues raised in the written and oral evidence received from the Committee on Parts 1, 3 and 4 of the Bill, and the table summarising the issues raised is at page 7 to 58 of the table pack. This is an opportunity to get any further information or clarification that we need in regards to Parts 1, 3 and 4 of the Bill and issues and proposals covered in the evidence received by the committee. And can I welcome again to the committee Brian Gimmick, the Deputy Director of Criminal Justice Policy and Legislation Division, who I understand may be joining us from London. So you're very welcome, Brian. Also Andrew Laverty, Head of Criminal Law Branch, the Criminal Justice Policy and Legislation Division, and Lorraine Ferguson, Head of Criminal Policy Unit at the Department. And just to advise our colleagues that this session will be reported by Hansard, and the transcript will be published on the committee's web page. And just that if we could ask the members and officials that we will take each part of the bill to be considered today in turn. Officials will be given the opportunity to make opening remarks on the relevant part, and any comments that they wish to make in relation to the issues and the proposals made in the written and in the oral evidence received by the committee. And there will be an opportunity for members to ask questions and explore issues before we move on to the next part. And I trust that's helpful to try and have some sort of structure as to how we work our way through that. So that brings us really to part one, the sexual offences, and we'll ask Brian and his colleagues if they want to make any comment in relation to the part one, the criminal conduct, which covers the voyeurism, additional offences, the sexual grooming, and the issue pertaining to pretending to be a child, and the miscellaneous amendments as to the sexual offences. Brian.
Right, Chairman. Well, thank you very much for inviting us to attend this meeting. I would note, as you say, I'm speaking from London. I'm taking a break from my summer holidays just to come to this meeting today. So you excuse me being inappropriately dressed. Very happy going through this actually to respond to the comments and questions from the committee members. Just looking at the first section, section 1, really covering first of all upskirting and on upskirting. I'm conscious that this raised a number of very interesting points from people giving evidence to the committee. So I'll maybe try to pick up some of those points. I would say that the key issues for us for this area is the provisions address an important legislative gap. And certainly when it comes to upskirting, we've consulted on legislating for upskirting as part of our review of child sexual exploitation and other sexual offences in 2019. The proposals were to legislate in this bill, and there was certainly overwhelming support for the proposal with no concerns at that time about motivations expressed. The removal of motivations, in our view, and certainly in the view of our legal advice, dilutes the offence and does not provide the ability to identify those who propose a future risk. So we also have some concerns about criminalising children and young people who act in a thoughtless or reckless manner in terms of carrying out this sort of activity without thinking through the consequences for their actions. So on this one, we understand some of the issues raised with the committee about actually motivation, but we're very clear that in fact there's quite a wide range of people who might get picked up in this offence, and the aim in actually putting motivation is to differentiate between certainly what people who might become serious or potentially dangerous offenders downstream and those who actually carry out this activity for less for reasons which are perhaps lower concern, therefore the criminal law may not be the best way to deal with them. So perhaps that's all I want to say at this point. I'm very happy to pick up any of myself and my colleagues here today. Very happy to pick up any comments or questions from the committee.
Okay, thank you, Brian. One of the issues that was raised for bringing in Gemma was NASUWT, that they pointed to research that concluded the difficulty of proving the nature of an offender's intentions beyond reasonable doubt may be contributing to cases never reaching court. Do you have any comment to make in regards to that?
Well, I would echo that the comments already. I'm not sure what's happened there. We seem to be getting a lot of echo. I think someone may have two sessions on. Anyway, I would echo what actually the committee has already heard, both from the Public Prosecution Service and also actually from the police. they are the notion of intent is something that they're very familiar with. So in fact, they would actually, but the justice system, the agencies involved would appreciate that. They've been party to us drawing up this legislation, insofar as we've certainly consulted them very carefully. And they are quite content that this is actually doable, and indeed it's a normal part of an investigation to look at intent. So whereas I'm not pretending in every case it's going to be simple, what I would say is that it's quite practical and doable, and certainly the justice system is quite used to taking that sort of thing on board.
Gemma?
Thanks, Chair. And I think my question has just been answered, but Brian, can I just ask you, were you just talking there that, when the individual carrying out the act is acting for the purpose of sexual gratification or humiliating, alarming or distressing an individual, are you saying that the department's willing to take that on board?
Sorry, I'm not sure I understood your question. You can repeat that, could you, Gemma?
Yeah, so, in terms of Clause 1, they're saying that a number of organisations have said that it's too narrow by relying on proving that the individual carrying out the act was acting on purposes of sexual gratification or humiliating, alarming or distressing an individual. So, this seems to be a bit of an obvious gap, and I know it's my view anyway, that it would require immediate attention. Did you just say there in your answer that the department agrees with this and would be taking that on board?
No, what I said was, in fact, certainly our view, and certainly a view of our legal advice, is, and indeed of public prosecution service and the police, is in fact this is sufficiently wide to catch these offences. Now, clearly on the margin there are always grey areas, but the reality is, in fact, that if someone it's actually about the intent, about where we go. But clearly, if someone actually, for example, takes an image which they're then selling on or whatever, it had been previously said, well, you weren't capturing people doing things for money or for a monetary award. Well, the reality is the fact they were selling it on may well be for somebody else's sexual gratification. Equally, it could well be actually the person, if it was sold on, it would cause fear, distress, alarm. So by and large, the public prosecution service, and I know you took evidence from them, so they'd have said this themselves. Our sense is, in fact, this is actually, there is sufficient there to capture the offences we're concerned about. Now, I'm conscious, that on the other end of the scale, you do have, people, taking photographs just on a whim or and without thinking. Or even accidentally taking a picture which turns out to be sort of that nature. And we're not trying to criminalise that sort of person. Clearly, when you have intent as part of it, the expectation is the police, if it was reported, the police will look at the intent of the individual. And if that person was, let's say, had a learning disability, or if that person was a child who had just been acting foolishly in a spur of the moment without actually thinking through consequences, then they aren't the people the offences and penalties are aimed at. But we're very conscious that there are people out there who take. I heard of a recent example. When someone was picked up, and when they actually looked at his phone, he had hundreds of images, similar images, and that wasn't a chance accident. That was someone deliberately actually going out of his way to undertake that sort of activity. Those are the sort of people clearly it should be focused on. In that situation, I think the motivation actually helps. And what we don't want to do is make sure we don't end up diluting the offence. So, we go for the lowest common denominator. Because clearly there'll be some people who commit these offences who need to go onto the sex offenders register. There's some who may well actually be potentially dangerous predators. So I don't think we want to go on the aim for the low, go for the lowest common denominator. What we want to do is actually differentiate between people who will technically commit the offence, but without actually real malice or intent to actually cause harm, distress, or indeed for sexual gratification. We want to differentiate between those and others who, in fact, are perhaps more dangerous or of greater concern, who we want to use a law against.
Okay.
I hope I've answered your question there, Gemma.
Yeah, so you're basically just saying that will cover those incidences then?
Yes, indeed. And I think that's what the PPS said in their evidence to you as well.
Okay. And why does our upskirting offence carry a lesser penalty than England and Wales? And would you
I
consider
think,
amending?
yeah, I think I answered that the last time, Gemma. So
Oh,
I'll just refresh your memory.
yeah.
Yeah, I think we noted that England had brought in a higher, they had put it into law, but they haven't commenced the law. So in fact, in theory, they could give it a higher offence, but they don't. At the moment, that 12-month level has not been implemented in England. So what we're suggesting is to actually the 6 months maximum, which is the norm for most cases in summary jurisdiction in the Magistrates Court. The 6 months is actually consistent with what's actually happening in England.
Okay. I was just testing you there, Brian.
Well, did I get the answer right?
Another question. Would you consider amending the bill to refer to image-based sexual abuse instead of revenge porn?
I think you'll find when you see the amendment, you'll discover we do not use the phrase revenge porn. I think this has been a phrase used possibly by us, but also I suspect by committee members. So if I'm guilty, I'm not the only person to be prosecuted. No, the reality is we're not using that. We don't really like the term either. I think we have maybe occasionally used it because, in fact, it actually gets some degree of recognition. And just to make sure that we're talking about the same things, we may have used it sometimes in the past. But you're exactly right. It's not the right term. Okay. We won't be putting it in the amendment. And when you see that, which I hope will be fairly soon, when you see that amendment, actually, I think you'll be happy enough.
Oh, okay, well, that's good. I'm happy to hear that. And my last question, we have an opportunity to lead the way on these islands by introducing a new cyber flashing offence. Has the department done any work on this?
Well, as you know, that when it comes to the cyber, to start with, actually, if you look at the bill, it obviously does pick up. It doesn't actually differentiate between different types of. 1 second, let me just look see if I can find where I'm. Well, rather than me looking at Lorraine, can you pick that up for a second, and I'll come back in again. I just lost my place in my notes. Or you'll also have to actually unmute yourself, Lorraine. You're still muted.
She might need to be brought in the spotlight or something, is she?
Well, so they're not quite sure what's happened there. We've had a little bit of trouble getting into your system, but no, you seem to still be mute, Lorraine. No, well, anyway, maybe I'll just pick up then. Clearly, when it comes to cybercrime, we're very conscious that Nornard is part of there's a UK sort of dimension to this one. So, in fact, we can't operate necessarily in isolation, not least because the cyber world doesn't end at the borders of Northern Ireland or even in the Irish Sea. And so, in essence, we have to operate really as part of a national sort of approach here. And to be honest, it's actually an international approach as well, because this goes beyond even the UK and Ireland's boundaries. So it's not that we haven't considered it. We actually believe, in fact, I know, for example, in another bill you're looking at on stalking, we clearly do make provision for where it is actually being used as part of an offence. So it doesn't mean it's been ignored. But at the same time, clearly we can't to put legislation in to manage cyber offences, which actually are transnational, isn't really within our power. Does that answer your question, or did you have anything more detailed you wanted to pick up?
No, that's fine. Yeah, thank you, Brian. That's all from me, Chair. Thank you.
Thank you. Sinead?
Thank you, Chair, and thank you, Brian and team, for being here again. Brian, I suppose in terms of the Clause 1 part, and I note, and you made reference that you have heard the presentations to committee, and there have been some quite compelling arguments put to us at committee around parts of this clause. And I'm just wondering, in terms of the department seem then to be almost standing by, the position that they adopted at the outset, in the first draft of the bill, in terms of the motivation piece and the descriptors. And some of the descriptors we also discussed were where it actually references the actual parts of the body and things, around that nature. Have you any mind to put any types of amendments against this clause that we're unaware of at this stage? Because I'm quite surprised to hear that, you know, that there hasn't been a bit of movement on this from your thinking at this stage.
Well, I think it's fair to say that you know, we've listened very carefully to all the information put in, all the evidence you've taken, and we noticed in some areas it has obviously been contradictory. So, in fact, to be honest, actually, we're happy enough that where the bill is as good a place as it can. We recognise, in fact, when it comes to motivation, you know, we wholly understand the lines that were put, and they were put quite forcefully. I appreciate that. But at the same time, the advice we're getting from PPS and the police service is, in fact, on motivation. They're comfortable with it. They believe it will actually cover the work. And they're the people on the ground that deal with these offences when they're going to appear. They're comfortable and confident that this is sufficient. And trying to move away from motivation, you know, opens up a whole host of other issues. If I wanted to move away from motivation, I would not do it by putting in a half-baked amendment. You know, I would take it out of the bill altogether and then put it into another bill, because realistically, you can't make good law by actually knee-jerk reactions to comments, even no matter how authoritative or good they are. The reality is that the way we build policy and legislation in Northern Ireland and in the UK is we do it on the basis of resolved policy. If we were going to make a radical change to this policy now, I think the only practical way of doing that would be to withdraw the whole section of the bill and actually rewrite it and then come back at a future date. Now, I don't believe, based on what I've got from the PPS and the police, that is necessary. And I believe, as do the police and the PPS, that this is law which is filling a gap. I'm not pretending. There are always ways of improving any law. And I'm not pretending, you know, it's the perfect law, but at the same time, it's what we have available. It will come in now. It will cover the vast majority of offences, and it will do it in a way which is consistent and appropriate. Now, I have to say that in going away from motivation, that raises a whole host of issues, not least the ones I described about diluting the offence. So you go for the lowest common denominator. Now, you might be able to actually produce different components and different levels, but to be honest, we've not given that anything other than cursory thought so far. And to actually produce new instructions, to produce new law, it's not something we're going to do between now and next week, or even now and next month. You know, it's something which would require us to go out and probably consult again, because again, when we consulted first, with only one exception, everybody else, only one of all the people who we consulted or the responses we got actually raised the issue of motivation. All the others who responded, and that's including a number of major legal organisations, all of them were happy enough with it as it stood. So, you know, I'm faced with the fact where we went out for public consultation, we got public and justice and voluntary sector inputs. This was not raised as an issue. To bring it up now and suggest it, when I have to say I've got actually some real issues about how it would work in practice. I don't think it wouldn't be prudent or appropriate for the Minister of the Department to try to make a last-minute change of such a significant nature without thinking through the consequences. And to be honest, at this stage, I'm not sure, you know, the consequences wouldn't produce worse law anyway. So, in fact, you know, this is one where, you know, we have no intention to amend it at this point. Certainly. You know, I understand there are different views on this, and, you know, there are some compelling arguments, but I think in a number of those compelling arguments, there were quite compelling counter-arguments, which, in fact, I think some other bodies did produce, and I hope I've just flagged a few of those today.
Thank you, Brian. And I suppose the biggest compelling argument as presented by you today is that the net would be maybe too wide, and that it would take in people and offences that this wasn't really the objective of the bill. But am I reading right here, Brian? I appreciate the department, you know, put up the draft and are presenting the bill, and heaven knows there's not enough in this bill, and I can give you a long list of what should have been in this bill that's not there. So I don't want to engage in any conversation where we even contemplate the possibility of taking anything from the face of the bill. But is this a slight warning shot to the committee to say that if there was an amendment, either from, because there are different players, as you know, in the legislative process, is this a warning shot to the department, or from the department to the committee or members, to say that should there be an amendment of such a fundamental nature, that the minister may not move that clause in the bill?
It's not my job to make it to fire warning shots towards anyone. What I'm just noting is, in fact, building up legislation is a complex process. I've previously told the committee it takes us typically a year to get from the start of the process to actually these drafted instructions going to the OLC. So, if changing, as we did with the stalking bill, where the committee asked us to make changes, and they weren't complex, they weren't raising any fundamental issues, they were actually going into detail, which we might have done anyway, but at the same time, we were both pointing in the same direction. Then clearly the minister was able to take that on board. And indeed, I think we've even taken some additional amendments in that one. So this shows a willingness to actually work with the committee. But certainly if the committee asks us to do something which is going to fundamentally change the nature of what's being proposed, when we haven't had time to consider it, we haven't had time to consult on the new direction, then as a civil servant, my responsibility to the department and to minister is to actually make it just clear that in fact, there are real problems with that. Now, clearly, if the committee want to make a minor change to something and they want to put in an amendment themselves, they can, of course, do that. But if you're making a major change, which changes the fundamental nature of an element, I'm not comfortable as someone who spent my whole career writing policy and drafting legislation. I'm not comfortable with just picking something out of a hat and say, "Oh, let's do that," but somebody said it's a good idea. No matter how persuasive it might be, I would still like to actually go through the normal process where we consult with, because we did consult on this previously, and there was the option for people to actually flag this, as a department, if we actually consult and we get responses, we can't really ignore those responses. So if you like, the direction to travel for me has to be in the direction to travel pointed out by the consultation. Otherwise, there's no point in us consulting it. It'll be a sham. Now, if the committee do feel that this is necessary, then I'm just saying it is actually a complex area. And my concern is by having casting a net, which is so fine that we catch everybody, there, what's happening is you've got big fish in there and very, very small fish. And ultimately, in fact, the concern for us from the legal perspective and the criminal perspective is the bigger fish. But if we're actually mixing them up with a lot of small of people we don't want, they get cover. So in fact, that's really our big concern.
No, thank you, Brian. I do hear you, and I can assure you, I would be the first to be shouting the loudest if there hadn't been consultation. So I genuinely take your point. I hear that. But I suppose we as a committee, that the committee stage of a bill is where you do hear voices and you hear the arguments and the counter arguments, and you weigh those up. And I suppose that's the stage that we as a committee are facing at the moment. And that's why it is good to hear, because you are presenting a counter argument to this, and I certainly think it's something that we need to take on board. But thank you, and I have a ton of other questions, but I'm conscious I'm taking up a lot of the committee time. Thank you, Chair. Thanks, Brian.
Peter?
Yeah, I suppose just to follow up on where Sinead left off, Brian, I appreciate the point that you've made. I would be a little bit disturbed with what's been said, because it seems to be, first of all, essentially, the committee effectively, I know you appreciate you're not suggesting that we don't have the particular power to do that, but the committee can have any amendments it wants, so long as the department, largely speaking, agrees with them, and it's not regarded as being significant change in that regard, which seems to slightly strike at the broader legislative process, because ultimately the Assembly itself will be sovereign, and we've all been at times stuck with either sort of changed legislation which either we greatly approve of or alternatively deeply dislike, but that's where the process goes. So I would have a little bit of concern in relation to that, and clearly maybe it does suggest that whenever consultation took place, if you got sort of one response which raised the issue of motivation, because certainly as a committee we've had quite a number of responses of that nature. It's been a pretty consistent message, and I don't know whether that's a question of some of the initial respondees didn't really realise this or took a little bit the eyes off the ball. I suppose that's maybe more of a point. But the point, I suppose, that was made to us in terms of, I suppose there's 2 points I would raise. Suggesting that a form of alternative would be based around where there isn't consent to the pictures being taken, and also where there is then a sharing of those, and I feel like the twin elements of that would really be sufficient rather than necessarily motivation, because I appreciate the point that the argument about throwing the net too widely. On the flip side of the coin, we've all seen at times prosecutions not take place where there's maybe been that little bit of doubt in the PPS's mind or whatever, that would they actually be able to prove motivation? And I think the motivation could become inadvertently a certain level of high hurdle to overcome on that basis. I can understand if it was simply the taking of a photograph, and although it's difficult to see how in many cases that, for example, upskirting could be done absolutely accidentally. It would be a very rare occasion it would be done entirely accidentally. Yeah. But if there's somebody who is both doing it without the consent of the individual and then sharing it, again, it's difficult to see where that is just entirely done accidentally. And I suppose, again, by way of a slightly counter-argument, the, call it unintended set of prosecutions, well, I suppose, to use the casting the net widely and getting the big fish into the net, I suppose to use that, any fisherman will always have a bit of discretion as to which fish they throw back into the sea in that regard. And so if we do genuinely get cases where there's a concern by the PPS or the police that actually here's somebody that has done this very either accidentally or maybe lacks mental capacity or whatever, in those circumstances, it'd be fairly commonplace, I would have thought, for the PPS not to prosecute at that point. And maybe it's a bit of a warning would be given to the person, etc. And the idea of that we would then be treating the big fish and the smaller fish and the worst cases on the same basis, surely that's the whole point of sentencing in a judicial process, that actually those who are the worst offenders would then receive the greatest sentence, and it may well be that somebody found, even if it does go to court, found guilty, who's of a much lower level would get a much lower sentence. So I just wonder if in terms of those points, you want to, maybe less of a direct question, but a response, because I'm not, I have to say, entirely convinced by the kind of slight level of threat of the sort of the nuclear option being used if there is some sort of change of this nature happening.
Right. Well, Peter, I'm very happy to respond to all those points. First of all, I previously was asked whether the department was going to bring amendments. So my answer was not about the committee. I'm sorry, not trying to create a constitutional crisis here. I was asked, was the committee, was the department considering amendments? And I said, that was my answer. Not actually that the committee has absolutely the right to consider and raise whatever amendments it considers. But clearly, if the department has been asked to do it, take an amendment, it has to look at that, look in the context of its understanding and whatever. And that was my answer. So I was not certainly for a second suggesting the committee hasn't the power or responsibility to put.
Except, Brian, what you did say, and again, maybe sort of, was essentially if there was an amendment of that nature that was so fundamental to that, there was then a question mark over whether this should actually constitute entirely new legislation, with a sort of at least veiled implication that that if there was something of that nature pressed, that the department or the minister may simply say, actually, we're going to have to withdraw. And I think actually possibly on that, I mean, again, I'm trying to think just the exact procedurally. Whether that's a question of actually a clause could be withdrawn, actually I think it would probably have to be, in those circumstances, the bill being withdrawn on that basis. I'm not quite sure the department, once it got to consideration stage, could simply, I mean, department may indicate that it wants to oppose the clause 1 standing part as amended or something of that nature, but I'm not sure they could actually simply withdraw a clause and leave the rest of the bill intact on that basis.
Well, I must admit, I don't want to get into minutiae of how it would work in that regard. What I did just note was, in fact, I was asked, was the department considering an amendment? I just noted that, in fact, if there was being, the committee suggested that they were looking for the minister or the department to make such a fundamental amendment, where in fact we hadn't actually consulted or actually had developed appropriate policy, that was a real problem. And in fact, in some ways, that was where I was saying, in fact, clearly actually having that going forward, if you had that amendment in where you couldn't stand over it, I think that would be a significant issue. And certainly it would probably make more sense if the committee felt there was a fundamental error in the law as it stood and which required a substantial change, that it would make more sense, to be honest, to have that worked out and issued another time. It was not a threat by any means. I'm just noting that, in fact, clearly developing law is a dynamic process. The committee, of course, can bring in anything it likes by way of amendment itself. If you're asking the Parliament to bring things in, we obviously have to look at them in the context of how the policy's been developed, and if it actually doesn't suggest that we haven't got sufficient background or supporting evidence, or indeed actually if we haven't worked through the elements, putting that amendment in would actually be substantially problematic. That was my point. I certainly wasn't trying to in any way sort of suggest that the committee didn't have the power to put its own amendments in. And I was just noting the practical problem. So it's because I want to produce good law. And in fact, if we're trying to bring in bits which we haven't thought through, and I know you may well have got some people at committee stage who have made particular points about motivation. But in fact, I'll come on to your questions now. I understand there are people who have made particular points about motivation, but it is a complex area, and that there are some swings and roundabouts involved here. So I wouldn't like just to say yes, that's fine, go ahead, without actually working through the detail. And I think that wouldn't be something you could do very quickly. I'm conscious we're getting very close to the end of the mandate. The Minister of the Parliament, as I've already said, have been very happy to pick up amendments from the committee, but where they actually going to require substantial amounts of work, we just haven't got the time to actually build that policy base on which to actually do it ourselves. Now, if the committee wanted to raise an amendment, of course, they're absolutely right to do that, and it'll just be decided in the House, in the Assembly, because the Assembly is the legislative authority. So I never suggested anything on that basis. But looking at your questions, actually, if I can now read my writing. Yeah, I can't read my writing, it turns out.
Brian, just to kind of reiterate then, it was...
Yeah, if you could, please.
One of the things that's been suggested to us, that if the offence was based around both lack of consent and the sharing, first of all, it is difficult to see where a combination of those things would happen and it being entirely innocent. And if it was a question of somebody had, maybe because they lack capacity, clearly if somebody lacks capacity, they shouldn't be being prosecuted in the first place. But that there would be a level, I think, of discretion that if there was, that is always probably employed a little bit by prosecutors in terms of where they feel not really appropriate and not in the public interest to take it through to prosecution. There's always going to be a certain level of flexibility within that. Those are the points. Just
well, what in some ways, what we're saying is, in fact, motivation and intent come in here. Obviously, someone can actually, if someone just takes a picture for their own personal use, and they're not it's neither going to cause fear and distress nor for sexual gratification, then in fact that's then that legislation isn't designed for that purpose. You could obviously have someone who actually takes an image for their own sexual gratification or to make someone else uncomfortable, in which case it would be covered. But if it's sharing, I'm conscious maybe what was being suggested on the motivation side is you could actually have someone taking the picture whose only motivation was money, and as he was going to sell the picture, to sell the photograph on to other groups. But if those groups he was sharing them were buying the picture to humiliate the individual or for sexual gratification, then it would still be covered. So I think when an offence is apparently committed, clearly the police will investigate. And you're quite right. Clearly, if someone accidentally takes a photograph, then that would be dismissed fairly quickly. If someone purposely takes a photograph, but there again, they didn't have any, they've just done it because they've been stupid or in fact, or reckless, to say that should be a criminal offence is, I would differentiate between, I think we've tried to differentiate between people who do things for foolish reasons without actually any intent to cause humiliation, harm, distress, or for sexual gratification. We're just trying to differentiate between those and some people who clearly are taking this approach. And that includes people who are taking pictures to sell on the basis that will then actually produce sexual gratification for others, or indeed actually allow other people to perhaps humiliate or otherwise make someone actually alarmed or distressed. So it is one where, in fact, our feeling was, and certainly the PPS line, which they gave to you separately, was that the motivation is an important part of it, and actually certainly that should allow the system to actually differentiate between accidental or low-level type behaviours and ones which are more sinister. And I think if you do produce a wider net where you catch everyone, you're quite right. Clearly, you'll have to sort out the wheat from the chaff, but you end up with a lot more people in the net. But if just taking the picture alone is sufficient to commit an offence, then rather than actually the motivation, that is the lowest common denominator. And clearly, within that group, you may well have people who have very sinister reasons for taking photographs, and even just to sift through the larger number of people to actually make sure you focus on those other ones is important. Plus, of course, their offence wouldn't actually be, it may well have been for sexual gratification, but the offence would have been actually just a basic one of upskirting, and certainly it would dilute the actual sort of nature of the offence. So now that was certainly our understanding of the law, actually. So that was our concern, that in fact, there are people who perhaps you would want to put on the sex offenders register and take other actions regarding. But if you actually have it as the lowest common denominator offence, it's perhaps harder to differentiate between those and others within that group. And your other point was about the Public Prosecution Service.
Oh, yes, right, okay.
Yes, so in fact, sorry, you couldn't remind me of your other point as well. I gave too long an answer to your first point. I lost the other two.
I suppose to some extent, look, Brian, I think you've sort of covered it. The point I was making, if there is some form of, of something of a nature that is either innocent or somebody lacking, for instance, capacity issues or whatever, surely, I mean, in those circumstances, the PPS, would be using a level of discretion not to prosecute. So I think the idea of the net being cast so widely that it drags in people who should be nowhere near the courts, I think it's a slightly moot point, I would say, to that extent. But I think you've covered that point already.
Yeah. No, I think I have. But certainly, you can find people who, in fact, accidental photographs, but it might well have been a deliberate photograph, but not with any sort of malign intent. And that could be sort of different. At the end of the day, you should say it might be hard to take an upskirting photograph accidentally, but it might well be somebody does something for us, but they're being silly, or they think they're being clever at the time, or whatever, but they haven't really got an intent to actually sort of humiliate the individual, but they haven't thought it through. And that can particularly be the case of young people who sometimes don't actually have necessarily are not perhaps as capable of thinking through consequences of their actions as perhaps adults. So you can find a situation potentially where people might do it on purpose, but at the same time, really, you don't want it to be an offence. It might well be something where the police would warn them to be more sensible, but in fact, it wouldn't be one which you'd want to prosecute.
Yeah.
And there are. I'm conscious. There are probably other examples, and that's why we actually have law and why we have courts. Because ultimately, there's a myriad of possible sort of explanation. What we're trying to do is make sure we actually capture the important ones, and certainly try not to inadvertently criminalise people on the margins, where in fact there might be other better solutions.
Brian, I appreciate the point, although I suppose the slight degree of counter-argument could be there's quite often a lot of crimes where if a watertight defence was, well, I wasn't really being all that sensible, or I didn't think through all the consequences of the actions, still there will be quite a lot of those in different spheres of life where crimes are committed, and I don't think that's a sufficient level of defence to actually negate a crime being committed on that basis. But look, I know obviously the next member's looking in, so I'll not press the point further beyond that.
Thank you. Rachel?
Thank you, Chair. Keeping my camera off because I've got some really bad tech issues in Bangor. Apparently, it's 9:45 on Monday, previous rather than whatever time it is now. So, I don't want to. I know there's been much focus in the last half an hour just on the motivation and the intent, and I suppose I don't want to exhaust that. Too much. I know just from conversations that the committee have had with those that have given evidence, in terms of what this offence as it currently is drafted would and wouldn't cover. And certainly Professor McGlynn was very clear that the offence drafted and the offence that happened in Northern Ireland that we're all aware of on upskirting would not be covered by the clauses in this bill as it is worded. And then the PPS had said that if there was no evidence of sexual gratification and there was no evidence of humiliation, alarm or distress, but if it was on the exertion of control, it wouldn't be covered by the motivation currently outlined in the bill. So just to be clear, and I know, Brian, you've covered about not changing, about warning against sort of the changing of motivation, and deeming it on consent only. But could there be room for additional motives to be added, or do you think that would have the same effect? And just something along those lines, and also just want to again pick up on the cyber flashing. In terms of operating in an international and a national way, it's my understanding that cyber flashing has been outlawed in Scotland since 2010. So I'm just wondering if there's something in there that we can look at for making it through this bill for Northern Ireland.
Right. Well, let's start off with just about the whole area about motivation. I must admit, our reading of the clause as drafted is if someone was actually trying to use an image for coercion or control, I'd be astonished if that didn't cause distress, anguish, humiliation from the person being controlled. Now, even if in fact they didn't actually recognise it, didn't mean it wasn't happening. But just as similarly in the domestic abuse bill, the coercion is not seen as a benign activity. It's seen as a malign activity. And even if the person that doesn't actually recognise it's causing them damage or whatever, it is. So I'm not actually sure. This is something which would certainly the court would determine. But I think, in fact, it's hard to see how that wouldn't actually be included. And certainly, the PPS, they gave their evidence separately, and certainly in the main, I think they were quite happy this was actually deliverable and actually was covering the vast majority of cases. And that's certainly been the view of the police, which, again, that they'd reflected to you. So, when it comes to putting in additional elements, clearly the committee certainly could consider that. The only question is what precisely you do and whether it would add any significant values. So, in fact, I'm sort of struggling to see how, in fact, someone who was actually using imagery for control couldn't be interpreted. And certainly even if the individual who was being coerced or controlled actually was so beaten down that they didn't recognise that this was humiliation and causing them anxiety and distress, a third party looking at the situation would probably come to quite a different conclusion. And the police, it's not unusual for the police to pursue cases where the victim themselves don't see themselves as a victim, but at the same time they very clearly are. So I'm not sure I would agree with you that actually wouldn't be covered. I think in law there's always a problem about just where you start and where you stop. And certainly I think what we have tried to do is actually provide quite a wide net for those more serious cases. If in fact there is a clever addition to the motivations, we can certainly, if you wanted to raise it, we would certainly consider that. But in fact, obviously, we want to get the law as good as it can be. But in fact, I'm as it stands, I think it should cover pretty well all the activities as we see them. Now, on the cyber flashing, I think we've taken the line that clearly this does actually tend to have a broader line that we'll have a look and see what the Scots have done on this one. And I'll never say never, but to say I'm just very nervous that we're getting quite close to the end of the mandate, and we have got quite a lot to do on this bill as we go forward. So in fact, I'll have a look and see what the Scots have done on that. And if there are lessons we could learn, I will say look at that. I would also say, though, that this isn't the end of the story. I'm very clear that there may be issues which are flagged up with the committee now, which are either outside of this bill. I note, particularly since we obviously wanted this bill to be a wider one than it actually is. Some things which were there previously fell off when we were obliged to narrow the bill. But there will be a miscellaneous provisions bill coming ahead, probably as the first bill of the next mandate. So where there are issues come up which are more fundamental. And I'm also, we will certainly look at those downstream, and there's certainly possibilities there. I'm also conscious that the Law Commission is looking at this sort of area as well at the moment. Now, they are looking at the idea. They're looking at a whole refresh of the entire system. So, in fact, picking up things, isolation from them is problematic. But certainly, we've had conversations with the Law Commission, and certainly my suspicion is they will produce a report sometime in 2022, and that probably means we will certainly look very carefully at that. And that Law Commission report has been, I think they spent the last couple of years developing that, and certainly so by the time they do get to the end point, it will be an opportunity to look afresh at this. And the fact that we're putting in legislation now certainly picks up points at this point of time. If law changes nationally, or if new ideas or refreshed thinking comes ahead, that would be for the next mandate. And so, so the department and whoever the Justice Minister is in the next mandate, of course, will actually will look at this very carefully.
Thanks, Brian. I appreciate that. I suppose just on the next mandate, we can't predict what's going to happen, but also there's nothing to stop a miscellaneous bill becoming a not miscellaneous bill again, just like has happened in this one. So, no, I appreciate your commentary on that. No, the Scots had banned it or had made a legislative change in 2010, and it has been in, and I believe there is a similar offence in the Republic of Ireland. And I know I just certainly would be something that we have been actively encouraged to look at, and I also know that it is becoming an increasing problem in Northern Ireland, and even in the last couple of weeks have had reports of it happening. So it's certainly something if we can do something.
Yeah, just to help me a little bit, when you talk about cyber flashing, but obviously we're talking about upskirting now. To have cyber flashing related to upskirt, there has to be an image. And if you create an image, and it's been put out and it's going to humiliate or distress or indeed actually provide sexual gratification in relation to the victim, I'm not sure I can see how it's not covered in the current legislation.
Okay.
Because at the end of the day, you can't have cyber flashing without taking an image. Actually taking the image and putting it out there for gratification, sexual gratification or whatever would in itself actually be an offence under this legislation when it comes in.
No, this is with regard to more of, the sharing of images rather than the actual act of upskirting or downloading.
But okay, so you're saying actually then passing on an image, and then you get an anonymous image from somewhere and you pass it on to a third party is what you're saying. That you haven't taken the image, but at the same time, the offence is actually the taking of the image. Now, ultimately, the image once taken, I think I can understand problems there just purely because if a third party receiving an image on the internet, how do they know it's been surreptitiously taken or taken without consent? I'm not saying it's necessarily a good thing. I'm just noting clearly the offence is actually taking the image and then passing it on keeping it or passing it on for various reasons. A third party getting innocently potentially getting an image on the internet and then passing it on, you'd have to show that there'd been some criminal intent. Now, the criminal intent in the first party is actually breaching the law and actually taking an image which, in fact, is unauthorised. If someone's received an image which isn't in itself obscene or in some other way unlawful, that gets you get into lots of very interesting questions there. So, in fact, I think this is probably a lot broader than just actually looking at upskirting.
Okay, thank you, Brian.
Thank you. I suppose, Brian, to conclude this part, I suppose the concern we have too is that in the evidence from the PPS, they said that if there was a case where there was no evidence of sexual gratification being the motivation, or no evidence that there was an intent to humiliate, alarm or distress, and it may be that the individual's only motivation was, for instance, around the exertion of control, then obviously it would not be covered by the motivations as currently outlined in the bill. So that was a view that was expressed to us by the PPS.
Well, it's very hard to understand how you'd get to that situation, because clearly on the coercion front, clearly it would have to be a non-domestic abuse case, because if it was domestic abuse, you're using coercion control, it would be covered by another law. So you're talking about someone who's not in a domestic situation, taking a photograph for coercion or control of someone who they're not in a relationship with. And I also think, so I think that's one question, just who is that sort of person going to be? And then I think the second question is, that if it's not taken for, if it's taken and it's for coercion or control, it's again hard to see how it wouldn't actually fit into one of the motivations. So I'm not sure. I'm not sure I understand where the PPS were coming from on that particular point. I'm quite finding it sort of difficult to see how you get that sort of case would arise. In reality, in law, anything can happen. But by and large, we make law to try to pick up the vast majority of cases. There's always going to be one on the margin. But I'll have another look at that. But I'm just struggling a wee bit to see how you'd find that case, which wouldn't be a domestic one, so it therefore wouldn't be someone with the offender was in a relationship with, but they were trying to somehow coerce or control them for monetary gain. But again, it's hard to see how that wouldn't be distressing or humiliating or causing alarm. Well, thank you much, Tim. I'll have another look at that one, but I'm just, if you have any more thoughts about what sort of victim that might constitute, we were very happy to receive those thoughts.
And of course, the other point that the PPS made was that proceeding simply on the basis of whether or not there was consent to taking the image would be in line with nearly all the other offences in the 2008 order. So that was the PPS's view as well.
Well, if the person consents to take the picture taken, are you suggesting that the person who had the picture image taken of up their skirt consented to it at the time? No. On the basis of whether or not there was consent, they said that proceeding simply on that basis, that taking the image would be in line with nearly all the other offences in the 2008 order. I'm sorry, you've confused me about the use of consent. Who's consented to what? Sorry.
Well, that wasn't our view. It was what the PPS was saying, in terms of.
I'm just not sure I understand what they're saying. Who is issued the consent for what? I'm sorry, Mr. Chairman. I'm trying to help you here on this one, but I'm not sure I understand what the point was they were making.
Yeah, but I think that they were taking the view whether or not there was consent, even whether there was or whether there wasn't. They were saying that the taking of the image would be in line with nearly all the other offences in the 2008 order. I just wanted to sort of clarify that point. Well,
if they were saying, if someone consents to a picture being taken, you're in a different ballgame, because obviously this is about an upskirting or for that matter down blousing. It's about actually things not taken. People, consenting adults can agree to all sorts of images being taken. Then other issues may come in, for example, on the whole issue about unauthorised sharing of intimate pictures, which will be an amendment to the order. So that's a different situation. But in essence, we're very clear there is a gap in the legislation at the moment relating to downskirting. That's very clear from actually recent cases, and both the PPS and the police are actually supportive of this legislation going forward, and they actually think it will add to the armoury of legislation that we have. So on that basis, whereas I think the 2008 order has lots of very helpful law in it, there is a clear gap, and it's our aim is our aim has been to fill that gap, and that's what this legislation intends to do. And I'm not clear that if someone consents to have the image taken, that changes the situation, and it falls out with the upskirting or indeed down blousing. So because if it's done with consent, then obviously an offence can't be committed. Now, then subsequently, if it's used for some other purpose, that might well be about trying to humiliate or whatever. That might be picked up by other legislation, but certainly this legislation is picking up the unauthorised recording of images and then subsequently their use either for humiliation, alarm, causing humiliation, alarm, distress, or sexual gratification.
Okay, we'll refer the evidence from the PPS you may have seen, but we'll just forward some of that to you again, just for your consideration.
I'll look at that specific point, and I'll also discuss it with the PPS.
Okay, thank you. Sinead?
Thank you, Chair. Just one very quick point, if I might. Brian, I appreciate what you were saying about the going off to give some more thought to perhaps the purpose, about obtaining sexual gratification or humiliating, alarming or distressing. When you're doing that, Brian, could I ask that you give some consideration to the thinking around the threat of? So in terms of prosecution, if the prosecution are charged with finding evidence of that it was for sexual gratification or humiliating, alarming or distressing, how do they do that if it was only a threat of? And I think that might go back to what the Chair's point is as well in terms of the consent, a consent at one moment in time, and then that image may be being used at a later time with the threat of. So I'd appreciate if you could give some thought to that, Brian, maybe, and come back. Thank you, Chair.
I'm happy to do that, though I think you would probably find, we are separately going to be looking at what was earlier inappropriately referred to as revenge porn, and actually the threat in that area of actually displaying an image which was previously taken with consent would certainly actually be covered there. And if the picture was taken with consent, but then was then be used as a threat of exposure to forced coercion, it may not be picked up by this bit of legislation, but I think it would, or this element of legislation, but I think it might be picked up elsewhere. But I'll again have a look at that.
Yeah, thank you, Brian. Thank you, Chair.
Okay, thank you, members. We'll just then go to Part 1, Chapter 2, which is the anonymity of privacy, which covers the anonymity of victims and also of suspects and the exclusion from proceedings. Any questions? Rachel?
Thank you, Chair. And just very quickly, this is brought up at the victim support submission, I believe, and my computer is now completely crashed, so I can't access my actual question. So in terms of the people who are, say, allowed in, as it were, to attend court with a victim in a sexual offence case, would that include the likes of the SOLAs, which is, I believe, the pilot scheme that is launched in April, I believe? Would they be, the likes of them be covered?
Well, and the short answer is it could do. The SOLAS is at the moment just a very helpful pilot going ahead. It's not covered by it at the moment, but if that pilot was successful and actually we were moving forward, there's certainly absolutely no reason they shouldn't be included. And again, there would be some other groups which support victims who would also be included. So, as I say, the answer is a conditional yes. As I say, they're not included at the moment, but it's just a pilot going ahead. But when that pilot actually is complete, if as we expect, it will actually show itself to be a great success, and we're going to roll it out, then I think that's at that point that's something which could be picked up.
Thanks, Brendan. Just on that, if there's other victim support, if a victim has a supporter and would like them to be there as part of the group that could attend, why would the likes of a victim support officer or somebody who's there with them not be covered by current legislation?
I think, in fact, I'll pass you over to Lorraine just to see if her sound's working now. If not, I will pick it up. Any chance? No? No, well, Lorraine, for some reason, Lorraine, for some reason, is actually without, lost for words. So, no, at the end of the day, certainly from our perspective, we want this, we want to support victims in the best way we can in this situation. So in that circumstance, certainly there will be a range of people who could be supporting. Victim support doesn't normally itself provide support actually in the location, as opposed to supporting the victim outside of the court. So, they may not be necessarily the ones you would put in, but there are clearly witness support and other people who, and indeed actually someone's friend or whatever support individual who could certainly be included. Our aim is to make this as easy a process for the victim, because we very much recognise that on one side, these are often very difficult things to hear in the court. And the victim, one of the reasons we believe, and Gillen believed, victims didn't come forward was because of this spectacle component. So we're obviously, the aim is actually to remove that, to give the victim the capacity to be comfortable. And if as part of that comfort they need support, then absolutely that should be managed, and they would be admitted.
Rachel?
I don't know if you can hear me, Chair,
Yes,
but my internet
yes.
just cut out there completely. So I will revert to Hansard to see what Brian said.
Yeah. Just
I think I agreed with you that in fact victims need support, and actually whereas the SOLA is still actually a pilot stage. If its pilot successfully completes, I'd expect them to be able to go in, and indeed other support organisations. Although victim support itself doesn't usually support the person in the trial, but rather around the trial. So it might not actually be they're the best people, but certainly our aim is to support victims so they can give evidence in a comfortable way without actually it becoming a public spectacle.
Yeah, and Brian, is there not an issue that was also raised, and maybe this is trying to help Rachel here in terms of one of the things that was said was by NSPCC, and it was around this issue of the variances in the interpretation of what constitutes serious sexual offence. So in the interest of and this is what NSPCC said, in the interest of legal clarity, would recommend the exclusion of the public from court should be extended to all sexual offence cases involving a child, whether in the Crown or in the Magistrates' Court. So that was going pretty, that was extending this a fair bit, but it was all around this issue in relation to what constitutes a serious sexual offence.
Well, we read that, and certainly our view was that to start with, actually, where the family courts, where children are normally in the family courts, there clearly is there are restrictions already. Clearly, children would be treated as vulnerable adults or vulnerable individuals. So, in fact, special arrangements are made for them, and that would certainly potentially include them actually being given the capacity to appear, not to appear sort of necessarily in the court. There's a variety of potential ways that they can be supported to give evidence in a safe and secure manner. So I think, in fact, I understand where they were coming from, but I actually think there's already quite good provision to ensure that children, and indeed vulnerable individuals, including vulnerable adults, are appropriately supported when they're actually giving evidence to make the processes as stress-free as possible. I also note that in Gillen, there are a number of recommendations which are progressing and will, I suspect, go forward in the next mandate on aspects of this as well. So, in fact, includes sort of Barner House sort of approach for children. There are a number of things in place at the moment, and I think there's work continuing along in those sort of areas. So, if they're not picked up in this legislation, certainly I would see them being picked up as we go forward.
So that would probably be in a sentencing bill, which is being considered?
It might be a sentencing bill, but it's also a possibility. I don't want to predict, because certainly it'll be my successor who deals with this. I don't want to predict which legislation we'll have in the next mandate. Particularly, we certainly will have a miscellaneous bill of some form and a sentencing bill, but it could also possibly be a bill covering Gillen, because there's still a number of elements of Gillen to be legislated, and there's a number of potential ways they could be taken forward, including a separate bill. But certainly that there are a number of areas there which are being worked on at the moment, and my expectation is once they have resolved policy, then the department and the minister of the day will be given consideration to how they're taken forward in legislation.
Okay, thank you. And just so we have clarity, Bernardo's and the PPS also did, and also the Women's Policy did raise this issue in regards to the expansion of the exclusion. So it's an issue that has been raised with us by a number of those organisations. Can I just bring you, if there's no other questions in this part, just to the issue that was raised by the police in terms of Clause 6, the increase in the penalty for the breach of anonymity, and what they were talking about, that they were recommending aligning the sentencing provisions towards the maximum period of the 24 months that are possible within the Magistrates' Court. Have you, because obviously what they said in their submission to us, that the sentencing guidelines around this currently don't reflect adequately the impact that this could have on victims and their wider family, and they would be of a view that it should reflect aligning the sentencing provisions maximum period 24 months within, which are possible in a magistrate's court.
Well, I think on that one, we've given some thought to that, and certainly in terms of the provision, ultimately, of course, the judges actually make the determination, or will make the determination of what constitutes a right sentence, and sentencing guidelines are there to help them actually make it in delivering that. Increasing the maximum sentence doesn't in itself necessarily mean that in fact the sentences necessarily will change. But this is one where we felt that the level of sentence was consistent with other equivalent legislation. And by and large, what we try to do in certainly my division is ensure where legislation with offences and penalties comes in, that there's a degree of consistency across legislation. It was on that basis we opted for that level of penalty.
Thank you. If there's no other questions on that element, we'll go to part 3, the prevention orders, and part 4, the final provisions. And is there any questions from members in relation to that part of the bill? Rachel?
Thank you, Chair. Right in the middle of this, but we might have covered this previously in discussions around the LCM on the police crime sentencing and courts bill, but I just wonder if we could get a brief outline the differences between the SOPOs as they operate in Northern Ireland and the similar or the same orders as they operate in the rest of the UK.
I'm sure you could, Rachel, but I'm not sure I'm going to give it to you today. I think we will drop you a note on that. I have to say, working from a hotel room in London, where in fact all my papers are on my laptop, and I'm trying to talk to the committee and also find things. It's much easier, I have to say, used to that I am to electronic media, it's much easier to have paper copies so you can put your hands immediately on things. Rather than going between several documents in the background. So I suspect had my colleague Lorraine been actually able to speak on this call, she would have probably given the answer on straight away. I can't immediately sort of get my hand on it, so we'll write to you on that one.
No problem. I have a follow-on questions on the same theme, so if it's okay, I'll send them through to Christine, if that's okay.
Yes, no, I'll do that, and we'll be happy to respond.
Okay.
Appreciate you don't have it stuff in front of you, so apologies on that one.
Okay, thank you. Members, have no other questions in regards to that, then can we just maybe deal with the issue in regards to the amendments proposed by the department that obviously, Brian, do you want to make comment in regards to the amendment being proposed by the department?
Yes, I can see if I can just actually see if I can find this in my my computer. Give me one second. I'll just see if I can.
The abolition of the rough sex offence and to widen the scope and strengthen the current law on abuse of trust.
Well, on the rough sex defence, which again we're trying not to use that phraseology, I think it's fairly clear cut. Actually, this is clearly sort of something where there's a gap in the legislation. So in fact, what we are trying to do is just fill that gap and allow this. At the moment, it's actually the common law does actually work and won't treat the rough sex defence as a defence normally. But we are conscious that there's been a bit of on the margins of that of the common law. There's been a few question marks, and what we wanted to do is get certainty. So what we're in essence doing in the rough sex or in the inappropriate use of images is actually to put it in legislation so there's clarity. Because our sense is, although actually they are covered, these offences at the moment in common law, there have been some challenges on the margins of the legislation of the common law offence, which we feel, if they continue, will actually perhaps create less certainty, and I think that's important. So what we've done here is try to put certainty in the law for the interests of victims.
Okay, Sinead?
Thank you, Chair, and I appreciate that bit of an update in terms of the amendments coming forward. I'm just really conscious the time frame that's in front of us, and waiting for a fulsome picture of what's playing out generally with all the moving parts on this bill. And I wonder, Brian, and perhaps it's not. To be fair, it's not your role to answer this, but I'm going to chance my arm anyway, just so I get a fuller picture. Are you aware of any other conversations being held in terms of amendments or, work that's going on? Because I think the committee will have a very short window to really tighten up where we think we could add value.
Well, the short answer is no, I'm not. The reality is, in fact, any amendments that the department makes, we would actually have to run past the executive, but there'll be departmental amendments. And we clearly are not, apart from the amendments which we've already alerted you to, and I think we've given you the text on some of them, but certainly not all of them. We're still working on a few of those, but in fact, other than those, I'm not aware of amendments. Now, clearly, an MLA can raise any amendment they wish when it goes to the next stage, but we're not working on any, no. And certainly I'm not aware of any, but that being said, I'd be surprised if there weren't some that come out of the woodwork.
Thank you, Brian. Thank you, Chair.
Okay, thank you. Members, any other comments in relation to the proposed amendments by the department? Anybody want to make any comment in relation to the one of abuse of trust? Which obviously, Brian, do you want to, because we had...
Yeah, I can say a little bit about it, Chair, if it'd be helpful. On the abuse of trust, I absolutely understand that we focused on sport and religion. And we did that, as I think I said at previous meetings, on the basis of the information we got from a panel of organisations of interest we brought together in a workshop primarily, but also in some conversations subsequently. And what we got was very clear evidence and indication from actually the associations involved with both religion and sport that a perception that this was very much needed. Aside from that, I at the time, I think earlier this year, I did speak to the committee and say we were proposing to bring this in the next mandate because for us to develop the full policy was going to require quite a bit of time. In the end, because of the interest and the perception it was going to be raised as an amendment anyway, we did accelerate that process. But in that process, we clearly didn't have the opportunity and time to look more broadly. Certainly, our perception is that we're covering the areas of greatest risk. But that's not to say there aren't other lesser areas where, in fact, there could be some risk. So what we did do, because we didn't go through a full process and the consultation we undertook gave us comfort in what we were proposing, but didn't, surprisingly, didn't flag other issues. And we certainly gave people the opportunity to raise those because they were in our mind. But we didn't get any real response which gave us comfort, gave us a perception that we needed to broaden at this point. So what we did do was, and what we proposed was to put in an enabling clause, which would have allowed, as we get evidence, which would suggest there might be other areas which we could usefully include, they could be done by an affirmative order going through the Assembly. So that would still give the Assembly its place, but it would mean that because we aren't in the position, I can't state with authority that I could go beyond this and actually have the evidence to back up what I was proposing. So we've gone as far as we can with the evidence we have from the consultation and our conversations with interest groups. But we have put in place an enabling clause. So and we will continue to look at this, if in fact we get more information and evidence which suggests there are other areas or groups which we can include at a later stage, that will be through through an affirmative order. So that actually should help. That should, I hope, reassure the committee that this is not us just trying to. This is not us just being sort of not being mindful of what others are saying, but it's just a reflection of the fact we didn't have the evidence to go beyond where we have at this point. But certainly this is something which will keep us a live issue, and downstream that there's certainly the possibility we could include other groups.
Yeah, because you'll be aware that in the evidence that we've received that there was issues raised by NSPCC, and actually it was then endorsed by the Women's Policy Group in regards to the fact that the gaps they concluded or they commented on, they said that they could be addressed by inserting, for example, a hobby or extracurriculum activity to give you a wider remit and catchment of the definition as it currently is in the bill.
No, I appreciate that. And I also would note, Chair, that we actually ran that workshop in collaboration with NSPCC, and we in our close association and working with NSPCC, they didn't give us any evidence on and didn't actually raise that as a significant issue at the time. Now, obviously, that was several months ago, and no doubt they've given further reflective thought. I'm just making the point that from the point of view of putting an amendment for the department to put an amendment in on this, I'd have to do on the basis of being able to stand up in front of the committee and say I have evidence which supports what I'm doing. I don't have the evidence, so that's why we've actually gone for the approach we've taken. We've given ourselves the capacity to pick this up as we get evidence which would sustain us picking it up. But, I think the committee has a right to expect if the department puts forward legislation and people like myself and my colleagues come here to explain and justify why we're doing it, I think you have a right to expect that we're doing it on the basis of actual hard fact and good consultation. And at the moment, I neither have hard fact nor do I have a consultation process which supports us extending that. That being said, I have to say that my starting point was an expectation we would go beyond the two groups we have done. And when we went to that workshop, we made it a reasonably broad one, and I had expected we might get more support for going beyond out of that, and we didn't. So in fact, at this stage, I've gone as far as I believe I can based on the evidence and the facts as I have at the moment. But at the same time, I can quite believe that as we go forward, some further information will arise. And I'm very happy to work with the NSPCC and other organisations going forward. And if they can help me to get the evidence which would suggest we need to broaden that, then the department won't be backward in raising the issues and extending the legislation. Okay. With the Assembly's, of course, approval through an affirmative order.
Yeah, okay. Sinead?
Thank you, Chair. Similar to your points raised, Chair, there did appear to be gaps. But Brian, are you also considering? I know that we've had representations, for example, the Children's Commissioner, in terms of they were seeking a vehicle, a legislative vehicle for the defence of reasonable chastisement to be removed from statute. And I don't know if you see maybe this as being a vehicle that could possibly be used for that, to that end. And was that something that came up in your workshop? But just while you mention it, thank you.
It wasn't in the workshop, because the workshop wasn't focused on that. It was focused on God. It was focused on abuse of trust.
Okay.
But that being said, both the minister and the department had indicated that the minister indicated she was minded to introduce an amendment on a justice matter, because the minister, and indeed actually I think officials, have real concerns about the law as it stands. But in the event, that would have been only possible if we'd had a full miscellaneous provisions bill. Because the minister was minded to introduce it as an amendment. In the event, the bill, we had problems getting the executive to approve the introduction of the bill, or even consider the introduction of the bill, until the minister agreed to narrow it to its current dimensions. That narrowing has had the effect, we think, of ruling that out of scope. And of course, the minister couldn't introduce an amendment of that nature without the approval of the executive. So that we think that isn't, the minister thinks that isn't a viable option. Of course, someone could try to introduce it in the assembly, but I suppose that would come down to whether it fits into the scope of the bill. And the minister clearly can't. Our responsibility, if she raised an amendment, she has to actually get it agreed by the executive, and I think that sounds unlikely given the different interests. If it was introduced in the assembly, then it would be a matter for the speaker to determine when it was in scope. And ultimately, neither the minister or the department, we aren't the arbiters of scope. The minister clearly wanted a broader bill, which would clearly put this into scope. That wasn't. We weren't able to protect that forward. So in fact, this is a narrower bill. It is a narrower scope. But I'm not the authority to determine whether such an amendment could or would be in scope or not. That would be a matter for the people who are drafting any amendment, and the speaker who would be who would determine whether it was acceptable for inclusion.
Thank you, Brian. Thank you, Speaker. Thank you.
Thank you, Rachel.
Thank you. I'll just touch upon that point on equal protection. I think it's perfectly viable that committee could look at this through an amendment if it does indeed meet the scope, which would obviously be the Speaker's decision. I suppose that was loud and clear from the submissions that we've received on this bill on the need for this. I just want to touch upon a point, Brian, on the abuse of trust. Instead about having evidence to sort of expand or extend the abuse of trust and what it covers, what kind of evidence do you need?
Well, I need some, because what's happened was, in fact, we certainly heard lots of quite good examples in terms of religion and sport, where in fact there were actually quite well documented examples. We know from our own talk to the police and others, of cases. When it comes to other groups, hobbyists and music teachers and others, I started off thinking that we would be covering those, but in fact, we just didn't have anyone coming forward giving us examples where this was a problem. Clearly, in the case of both the sporting and religious areas, we actually had sporting organisations and religious organisations coming to us saying this is a problem, we need to sort it. We didn't have people coming forward from other areas, and in our consultation, we included a broader set of groups than just religious and sporting groups. And I just literally I'm not clear just how big a problem this is or not isn't. And I think if we're going to try to actually extend this, and I'm not saying we shouldn't extend it. I'm just saying we hear anecdotal stories, but in fact I haven't really got any significant evidence that about this. Now, I accept on abuse of trust, by and large, it's perhaps harder to pick up evidence purely because if it's not unlawful at the moment, then the justice system won't pick it up. So we're reliant upon third-party groups. Now, clearly in sports and religion, the groups are coming forward and saying, we are the governing bodies of these things. We are seeing this happening. This is causing us concern. The government needs to actually take steps. And here are some examples where things have gone wrong because in the absence of this, that was actually very helpful. That to me was sufficient for me to be reassured going forward. But on the other groups, I haven't picked up anything significant which suggests that this is a real problem. My suspicion is it will be a problem in some cases, but in fact, I can't go to the committee with legislation and saying, well, I have this gut feeling that this isn't something happening here. I need to have a bit more than that. So in fact, I'm really looking for, in the sporting and religious areas, the bodies actually came forward and told us that, they were the governing bodies. They were seeing these things happening. They were being asked for advice about how they deal with individual cases from clubs and whatever. So that to me was actually quite compelling. I'm a bit short on anybody from any other areas coming forward and giving me equivalent advice, and that's my issue. So that clearly, if there are cases arising, and they can be brought to our attention, then in fact, obviously, I didn't want to wait. Well, had we actually kept this until the next mandate, I would have run a full policy process, and we would have gone out on the highways and byways and had more time to go and gather the information. But because it was decided to put it into this mandate, the department had to run with what we had to produce, because as you know, to get these things in, we really needed to have drafts in with the OLC by beginning of the summer to get the amendments drafted. So at a certain point, we had to sort of cut and run. But in fact, this is something, that's why we put in that enabling clause, which means, we can, if we get people coming forward and giving us more advice, or if we can find it, then we can take it forward. But it's not for the want of it's not for a lack of willingness to extend this. It's just, we need to do it on rational, logical basis. And I had both religious and sporting organisations in our workshop giving me very clear advice that they were seeing these cases, they were having to give advice to different clubs or whatever, and presumably parishes or religious bodies. And on that basis, they were very keen that there was legal support for actually outlawing this in their sectors. So I didn't get that from other sectors, and that's why we've gone as far as we've gone and no further.
Thanks, Brian. I appreciate that, and I suppose it just doesn't sit well with me in terms of, okay, well, we need there's anecdotal stories, but we need say a body or an organisation, representing an organisation, to come forward with examples, because that means examples will have had to have happened. And I suppose the whole point of this campaign was to close the loophole. So it's just not sitting well with me in terms of, okay, well, we'll need to have more evidence of the abuse of positions of trust happening to close it.
I'm happy to have historical, it doesn't have to be next evidence, it could be historical evidence, but in fact, indeed, that's what I was getting from the religious and sporting authorities. So, it's essentially, I think, we had to work with the information we had, and that's on that basis it went forward. I'd started off expecting to go further, but in fact I just have been constrained by what information we actually got back. Now, clearly, if others come forward, by putting an enabling clause in, that does mean we could actually act reasonably quickly if people come forward after today even. But certainly it's not going to be fit into this bill very easily. But if someone came forward today, clearly we're very tight for actually moving things forward. But I think, in fact, I actually understand where you're coming from, because I had the same sort of feeling. But we can't really legislate on the basis of feeling. We have to have some sort of basis for taking it forward. And certainly a historical anecdote usually means, I've heard this happening, and you can never pin down precisely who it was or where it was, whatever. And to be honest, I haven't received many anecdotes. I've more received people thinking, well, theoretically something could happen. I'm not quite sure that's the basis to legislate on. But in fact, clear where we do have or where we can get advice, some hard cases or hard evidence about historical cases, that would be very helpful. And certainly this could be picked up, because putting that enabling clause in will give us the capacity to backfill. So if more cases or new areas come along where this could happen, that they could be added in later.
Thanks, Brian. Thanks, Chair.
Thanks, Rachel. Obviously, Brian, as well, we had the Human Rights Commission raised with us the Lanzarote Committee recommendation that the concept of relationships of trust should be afforded what they described as a broad interpretation. And obviously that is an issue that they have raised on a number of occasions and have the report.
Yes. Sorry, I'm trying to think of the detail of that one actually. So, what do they define as a broad interpretation?
Well, they said that the committee cautioned state to avoid any rigid listing of very specific situations, as to do so would risk leaving children in other situations without protection. They also suggested that states to review the legislation to include a reference to the notion of circle of trust, which would comprise members of the extended family, including new partners, persons having caretaking functions, including trainers of any kind, or exercising control over the child professionally or on a voluntary basis. Well,
I think, in fact, clearly there are a range of potential people who could come along, could be affected. The problem is, well, if they're saying about actually not being too prescriptive, because in fact it could be a wide range of people, I think and that's often how we usually try to avoid drawing up lists, because once you draw up a list, whoever falls outside it actually then the courts may interpret as not being covered. But on abuse of trust, clearly what we have done is we've looked at actually what's been provided in other jurisdictions. And certainly we've taken a similar approach to what's been progressed in other parts of the UK and beyond. To go further, I think it would be something which we would require a great deal more work on. And that's purely because, in fact, as I said to you before, ultimately this was something which we wanted to put in quickly, just to get the highest risk areas covered. And putting it in this mandate meant, in fact, we didn't have the full policy development process, which would be the norm. And that gives you some advantage of actually getting things in quickly to the areas which we think are the most high risk. But at the same time, it has a disadvantage of us not having had the time to really go through and consider a lot of these other groupings. So I think we are where we are. This is something which we could pick up and progress and develop further as we go along. And certainly that's something which we will look at. But as it stood, we to get this into this bill, we had to make judgment calls about what we could cover, and we did that based on the evidence we had gathered, and that was sufficient to support what we've put down. To go beyond that's going to require some additional work, and certainly we've created the opportunity to introduce other groups or categories at a later stage. So that's perhaps as good an answer as I can give, I'm afraid.
Just on one final point, Brian, could you maybe make comment in regards to one of the other issues that was raised was in terms of the child abduction warning notices, and it was about allowing them to be served on adults regardless of the age and care status of the child?
Yes, well, they are actually sort of, if I just see if I can dig up my notes in this bit, sorry, this is not running as smoothly as it does when you're actually at the committee, because in fact, trying to work off a single screen and several documents on it. If you just give me 1 second, I'll see can I find my notes in this one. I wonder, can I actually even just look it up actually? Find. Sorry for this delay.
You okay? You all right, Brian?
Let me see. Ah, yes, here we go. Yeah, so there was an issue. Yes, and I think we noticed there was an issue. Sorry. Yes, yeah, we did notice there was an issue about. Essentially, what we had been doing, the clause 18 on SOPOs is really about bringing the offence of adoption of a child in care in, but there was an issue I noted about the age thresholds, applicable to the CAWN, the corns. Yes, and I think they were suggesting we close the gap in the age threshold. Now, I think perhaps all I can say to that is essentially the corns form part of a wider work being taken forward by the department in our review of the law of child sex exploitation. We did consult in 2019 in addressing the particular recommendations of the Marshall Report, and we did, as amongst other things, looked at whether there was a gap in the law in regarding child abduction offences. And I think that related to concerns about inconsistencies in age thresholds. Interestingly, the responses to the consultation were very mixed, with arguments presented for and against an extension of the law. So, in essence, we didn't get the answer from the consultation was, in fact, this was quite complex, and there were some people who were actually thinking, yes, we should do this, and others were considering it was impacting on the liberties or the free choice of individuals. So because the arguments were so mixed, we obviously need to carry out some further work before we consider extending the law. Now, this needs to be carried out with key stakeholders and interesting parties to work out how best to go forward. And I think it's fair to say that in determining the need for any further protection, we have to balance the rights of young people to enter safe consensual relationships. And that's, there's clearly a potential to criminalise partners of 16 and 17-year-olds, which would run contrary to the current law, which allows such age groups to make their own decisions. So we're proposing to take this work forward, but it'll really be the next mandate before we do that. So it's an issue which we're aware of. We did try to get clarity on it previously, but in fact, the consultation had the effect of stopping us in our tracks insofar as we didn't get a clear response. Indeed, the responses we got were somewhat contradictory. So clearly we need to do further work on that. And that's something perhaps, in the next mandate when we're looking at this, we'll be reflecting the issues and the way forward with the committee again.
Okay, thank you, Brian. Rachel, just want to check, have you another question? Just your hand is up.
Sorry, no,
Okay.
apologies.
Okay, that's all right. No, just want to be sure. Thank you. Brian, thank you. And just with the appreciate the time that you've given today, and also to Andrew and Lorraine, even though we weren't able to get them online, but we appreciate them still being there. So thank you for the time, and we'll no doubt be coming back to many of these issues over the next number of weeks. So thank you again, Brian.
Well, thank you very much, Mr. Chairman, and certainly I would hope that next time we're there, we'll be there in person again, and again with my team with me, because it's not very easy when you're in 3 different places, or 4 different places, and then of course I'm sure the same's true for the committee. So I look forward to seeing you in the new year, and I'm sure I'll be seeing you quite a few times in the new year. So. And certainly I'll pick up all the points raised, which I said I'd take forward anyway.
Thank you. Thanks, Brian. Thank you. Members, can we just get an agreement that we would forward to the committee the issues paper that we have, which sets out all the various points that have been raised by different organisations, so that the department has a copy of it? Just, I think it would be helpful. And then they could make any further comment in relation to it. Agreed?
Agreed.
Thank you. Okay, members, moving on then to item 5, the January monitoring round oral evidence session. Department officials are attending the meeting via Starleaf today to provide the briefing of the department's 2020-2021 January monitoring round. The relevant papers are at pages 22 of 87 of the meeting pack, and also officials will outline the next steps of the 2022-25 budget process and are due to attend the meeting on the 20th of January in regards to the Department's draft budget. And can I welcome to the meeting this afternoon Deborah Brown, the Director of the Justice Delivery Directorate, Andrea Quayle, the Head of Financial Planning, Strategy and Support, and Louise Blair, Head of Financial Planning and Support, Department of Justice. And Deborah, if you want to just make a few opening comments in regards to the January monitoring round, and then we'll take questions. Thank you.
Thank you, Chair. Thank you for the opportunity to come this afternoon to provide you with an update on the January monitoring round and the draft budget 22 to 25. As you said, I'm joined by Andrea and by Louise this afternoon. So turning to the main area for discussion today, January monitoring round. This is the third and final monitoring round of the year, and this year continues to be difficult in terms of the budget pressures and the uncertainty that has been created by COVID-19. As part of October monitoring pressures were reduced from 28.4 million at June monitoring round to 26.7 million. While pressures increased and decreased across the business areas, the main change was as a result of a 3 million reduction in compensation services bid. The Department bid to the Department of Finance for 25.4 million, with the remaining 1.3 million being managed by the Department. Allocations of £2 million were agreed by the Executive, which left pressures remaining of 24.7 million. January monitoring round has seen pressures reviewed and have now reduced further from the 24.7 million down to 19.6 million. While pressures remain at the October monitoring round have decreased by 13.8 million, significant new pressures have emerged as part of the January monitoring round, totalling 8.7 million. The most significant of this relates to a PSNI legacy case, which costing approximately £7.8 million. In relation to the PSNI pressures included within that 19.6 million, a bid will be submitted to the Department of Finance in the January monitoring round for 7.5 million in relation to that legacy case. The Department has a small legacy easement that is able to contribute towards this, which is why it's brought down to the 7.5 million. And it will also bid for the 3.3 million in relation to the EU exit pressure. This is funding which is for the NI protocol. There has been a bid placed with HM Treasury, but as yet has not been met, and we continue to liaise with the Department of Finance on this. The Department will also then internally allocate 4.8 million from the funding that is available to meet some of that 19.6 million of pressures. And as I said, will submit bids to the Department of Finance. Those in total will be 14.8 million, which will include the PSNI pressures that I've just outlined of 10.8 million, and 3.5 million in relation to legal aid, and 0.4 million for the Court's deprivation of liberty and review tribunal pressure. As this is the last opportunity to bid to the Department of Finance for additional funding, should the bids not be met, the Department will then need to manage these remaining pressures of 14.8 million. And this may involve slowing down or stopping some expenditure. We have also returned ring-fenced identified easements of £855,000 to the Department of Finance, and this was in relation to COVID-19 funding of 805 across various business areas and £50,000 of the Office of the Police Ombudsman for historical investigations. This was identified and notified to the Department of Finance as part of a recent exercise that required all departments to identify and provide easements in advance of the January monitoring round. Moving to capital, the 21-22 budget was allocated in full as part of the opening budget exercise. As previously notified, easements of 11.8 million were surrendered across a number of business areas in October monitoring round. The majority of this was for 10 million for the Police College. Further easements of 7.7 million identified in January monitoring round will be surrendered to the Department of Finance, bringing our total easements this year to £19.5 million. We will also then, in January monitoring round, update our ring-fenced resource DEL, which is the technical budget to cover depreciation and impairments. We've received bids of 3.8 million for ring-fenced resource DEL, for which the department currently holds 0.9 million. We will allocate that 0.9 million and submit a bid of 2.9 million to the Department of Finance. This will then leave the department with no remaining unallocated ring-fenced resource DEL. Historically, underspends materialise across departments during the latter part of the financial year, and while there are no guarantees, it would be expected that funding would be available to meet the 2.9 million bid for January monitoring round. We've also increased our annually managed expenditure budget, or AMI. We will agree the AMI movements and bids, and that will result in an increase of 136 million. This figure has been revised as part of the stage 2 of the January monitoring to ensure sufficient cover is within the spring supplementary estimates. So moving then to the budget 22-25 process. So the Chancellor announced the outcome of the multi-annual spending review on the 27th of October this year, which provides the Executive with funding envelopes for each of the 3 years of the budget across 22-25 period. The Finance Minister unveiled the Executive's draft budget for 22-25 on the 10th of December. A 12-week consultation period on the proposals set out in the draft budget has commenced as of the 13th of December, which will give the public their opportunity to have their say, and this consultation process will run until the 7th of March. You've been provided with copies of both our resource DEL and capital returns to the Department of Finance, and I note that you were provided with additional information following your request on the 6th of December in relation to the Department's resource DEL bids for that budget. And as you said, Chair, the Department will be back at the committee in mid-January to provide you with some further updates. So in conclusion, I hope I've provided a suitable overview of where we are in terms of the Department's current financial position, both in January and the outcome then in this draft budget. So I'd like to thank you for the opportunity to brief you today, and we are very much looking forward to the views of the committee and happy to take these on board. Thank you, Chair.
Thank you, Deborah. Thank you, and thank you for your help in regards to walking us through this process. Obviously, I don't want to get us sidetracked onto the issue of the budget, other than to say it is a very, very worrying situation where we see comments being made today by the policing board in relation to the possibility of the drop of some 900 officers, and given the large proportion of the bill or of the budget that goes to policing, obviously that is a grave concern. But I think that's something that we will have to return to try and keep our focus on what we have in front of us today. And that brings me to the issue in regards, which is related in a sense to the PSNI, which is another pressure, and that is the legacy issue is not funded for. And we now have a situation where an unidentified legacy pressure has now come about and has resulted in £7 million being required. Deborah, is this sustainable in the way in which these demands, coming albeit through a court process and through the access that people have to the judicial process, which is entirely their right, but we have now a situation where there is this demand that is now a requirement for the PSNI to meet, and they have no resource cover to pay for it.
I think you raise a very important point, Chair, and the issue of sustainability is one which is a concern across the board, and our concern with the future 3-year budget that has been proposed at the moment is that there's a massive issue around the sustainability of this and the implications it's going to have for police and other services across the justice system. And it is unfortunate that this case has come at this point in the year, where there is less scope for us to take appropriate action. And as you can see, we are having to bid for this because we have no scope within the DOJ to manage this ourselves.
Just another issue in terms of, and then we'll go to members, but in the 334k was held by the department following the June monitoring round was earmarked for Gillen, but will now be used to fund other pressures in the department. Why is this no longer required, and are there any other easements identified in respect to Gillen?
I'll let Louise answer that one, Chair.
Okay, thanks, Deborah.
Okay, Chair. Thank you. Just in terms of the money that we've held for Gillen, that was part of the department's baseline. It was identified at the start of this financial year. There have been easements throughout the year which have been held centrally for any Gillen pressures that might come forward. Those easements throughout the year have mainly been in relation to perhaps delays in filling posts and being able to take those posts forward. I think also there has also been a smallish underspend in relation to the costs associated with the remote evidence centres, not requiring quite as much funding as have been expected in this year because they've been able to make use of some existing facilities. So that has been held pending any further requirements for Gillen, but because those haven't come forward then and the Gillen projects have enough money within this current financial year, that money has been eased.
Okay, thank you. And maybe just one other point that I meant to ask to Deborah in regards to the capital position. Is there a risk to the 11 million in relation to the police college?
So at the moment there's a business case that's being drafted and within the capital that's been allocated as part of the budget, we are now doing a refresh of our capital requirements and prioritising those, and so within that the police college is one of the ones that I know is sitting in one of the higher priority categories. So we'll be looking at that in more detail and happy to bring back some more information after we've completed our refresh exercise.
Okay, appreciate that. Thank you, Deborah. Okay, go to members. Peter?
Thank you, Chair. Thank you, Deborah, and the team for the information so far. And I would echo perhaps the remarks of the Chair, but obviously we're coming back to it at a later date in terms of the wider budgetary consideration of move ahead from 22 onwards, and I suppose particularly the impact on police numbers, which you should remember as well was an important sort of NDNA commitment. But just turning on the January monitoring round, Deborah, you'd indicated, which I suppose understandably it may well be that the department doesn't have a great deal of choice in this matter, but we're well aware that generally speaking in terms of monitoring bids, and obviously this is the last opportunity really this year, that it's quite often that the bids are put in are considerably of a much greater scale than what is available for allocation by the executive. So we don't know, obviously on that basis, we don't know how much, if any, of the department's bids then will be met in terms of those pressures. I suppose just highlight, I think, Deborah, you had indicated that at least largely speaking that if the bids of about 14 million weren't met, I don't know how much of those direct bids could ultimately themselves be put off, but you indicated that then the only way to make ends meet was then to look effectively existingly within the overall envelope of money for 21-22 and to start either sort of stopping particular activities or perhaps long fingering spend, so to go at least outside this financial year. Maybe you're not in a position to say this, but in terms of, I suppose, two-part question, in terms of then the areas which have been identified as potentially being that would have to be put off this year if the 14 million wasn't met, what areas have you identified at this stage, and what's your process in terms of identifying what then wouldn't be spent? What's your process of prioritisation within that in terms of where either delays or cuts would have to be made?
Okay, so breaking the 14.8 million down, the 7.5 million for the PSNI is one that, first of all, we will go to the police to see if there's any way that they can manage that, and they can come back with proposals. With the EU exit money, again, we still remain optimistic that that funding will come forward from HMT, and so therefore we can park that. We have just over 700,000 that we're holding just in case, and in that case then of course then we would look at what the deprivation of liberty pressure is at that time and hopefully seek to manage that. In the case of the remaining bid for legal services, has had historically a baseline that has been below our normal demand. The baseline for the actual fund itself is 76 million, but normal demand is around about the 82 million. So we always start off behind a wee bit off on this one. But then of course this year we've had the issues of COVID recovery, and we've also seen an increase in demand where the claims are coming in an awful lot faster than they have done in the past. And indeed that is obviously a symptom of COVID as well. But within the department, you will notice that we did have some easements, and we did allocate £2 million to LSA, which allows them to increase their spend. So their 76 million baseline has increased over the period, bringing them back up to about 88 million plus the 2 million that we have allocated internally. So it does bring them closer, over the £90 million mark, which is well above the baseline. However, we know that the demand is still very high for legal aid, and if we don't get the 3.5 million bid met, that does mean that we would slow down payments in February and March, which is not ideal, because of course then what we were doing is we were going to be increasing our backlog, which then just pushes pressures into next year, but it's the only way of managing a potential overspend. So I hope that gives you a flavour of
So Deborah,
the way that we look at this and we break it down.
That's okay. Deborah, it would be fair to say that in terms of the bids, that depending upon what was met, and I appreciate the point you've made in terms of where you have optimism and where it's perhaps a little bit more simply dependent upon where the executive lands, that effectively, if those are either partially met or in some cases not met at all, that you'd look to effectively, within those sort of heads of unit, if I can put it that way, that's where you would seek to deal with whatever pressures are there that aren't met, rather than looking outside of those bids.
Yeah, it would depend obviously then on what the outcome is.
Yeah.
We would then probably have to go back to the board, but you will see that we did start the year with much larger pressures, and those have been managed within the department, and indeed quite a lot of those have been managed by the fact that we have not filled vacancies and not been able to fill vacancies. But again, all of that has a significant impact on our service delivery.
Maybe, Chair, I don't know whether maybe it's maybe a little bit tangential. Maybe should declare not quite an interest, but I suppose as a non-practising member of the bar on that basis, though I'm not either due any legal aid or indeed aren't sort of haven't sought any legal aid or anything of that nature on it, but maybe we should declare that as an interest if we're talking about potentially some fees to the legal profession, potentially moving at a slower pace, depending upon what happens in terms of the monitoring round side of things on it. Okay, thank you, Chair.
Thank you. Gemma? All right.
No, you're okay, Chair. My questions have been covered now.
All right, thanks, Gemma. And then it's Sinead.
Thank you, Chair. And to be fair, some has been covered there in the last piece, but I suppose, and it may be, I suppose, I appreciate this as a sort of a headline figures, and I do appreciate the briefing and bring us up to date in that. But sometimes there are, I suppose, commentary that then runs under it, and it does worry me, and it is getting closer, I appreciate, to the operational running of some organisations. But in terms of the reference to the Gillen, the money that was set aside for Gillen, and then there was an inability to perhaps appoint people to posts. Would it be possible to get a further breakdown on what that actually means, so we have a clearer idea of where the weaknesses are in the system? Because whilst it's well and good to see money being reallocated and used for different things, I just don't feel I have a true picture of what's not there. And I give an example of that. I know during our October monitoring rounds there was reference to a significant project that was under TBUC hadn't proceeded, and we had requested, I think, a breakdown of what exactly that was. You know, it's trying to understand where the holes are in the system, and I appreciate. Apologies, that information may have come, and I did intend to raise it with the clerk, and I didn't. I accept that I haven't done that, but I just wonder. I just don't like that. Perhaps there's always this glossing over, because we're very quick to know where the money's going, as opposed to where it didn't go. Is there any information you could provide on that? Thank you.
Thanks, Sinead.
So can I just clarify, sorry, you're asking it with regard to Gillen, so we can give you some more information around the progress that has been made on Gillen, give you some information on the spend that's planned over the next number of years, which will then address the issues that are coming through on this. Is that what you want specifically on the Gillen?
Yes, and also you mentioned that that some of this money had come about, couldn't be spent because posts weren't being filled. What posts are they?
Okay.
You know,
sure. Well, yeah.
And where are they? You know, and are those posts part of the response to Gillen? So I'd just like to have an understanding of where they are. And the likes of that TBUC money, did that project ever come back online, or has that fallen off the radar completely?
Okay. And that TBUC project is back. It is still online, and we'll bring you back some more information on that.
Thank you. Thank you, Chair.
Thank you, Sinead. Rachel.
Thank you, Chair, and apologies if some of this has been covered. I'm still having some IT issues here. I think I'll just start dialing in from Stormont because the internet will be better. So in terms of I just want to touch on TBUC there, and I noticed just in the submission, I'm not going to ask for specific details, but why is there no end of year flexibility within TBUC? Is that a requirement? Or is that something that's within the sort of from TEO, or is just there isn't any end of year flexibility?
There is no end of year flexibility.
And is that something that the department can request, or is it just never been looked at?
No, there has never been end of year flexibility for quite a number of years. A long time ago, you would have got some end of year flexibility on capital sometimes. But the whole issue of end of year flexibility no longer exists for us. It does as a Northern Ireland block, and that is managed by DOF. As you know, when we come to the end of the financial year, there is amounts that can be carried forward, and then they are reallocated as part of the budget process. But there's no end of year flexibility for departments.
Okay. No, thanks. Just out of interest, thank you for that. In terms of a few specifics, just the department are due to commence some of the Domestic Abuse and Civil Proceedings or Family Proceedings Act regulations in February. Is there any money or resources been allocated within this January monitoring round for them, for rolling them out, or for a public awareness campaign regarding those regulations being commenced?
So I think that there's no specific bids for them. Those will be covered by their own budgets. As far as I'm aware, I don't think there's any specific bids for those. No, but those will be covered by their own budgets.
Okay, thank you. And similarly then with the committal reform bill that's just been passed final stage, I suppose it's usually about 3 months until a royal assent, but just that might come in at the end of Q4. Is there any would that then be the same story on committal reform within the Courts and Tribunal Service and front loading of the High Courts and so on? Should that be commenced before the end of financial year? So
again, those are covered within the baseline budgets.
Okay, no problem at all, thank you. And then the 421,000 in the submission for transformation costs within the Northern Ireland Prison Service, is that part of Prisons 2020? Do you know, or is that additional?
Sorry, I'm just trying to find that one, Rachel. This is a bid that you're referring to, is it?
Yeah, it said 421,000 for transformation costs in Northern Ireland Prison Service, and of course I cannot find the exact page now. Apologies.
Is that in future year bids? I think maybe rather than in this current year.
Oh, I could be sorry. Everything is going wrong for me today on IT, so apologies. I'm absolutely no issue with it if I've got that one wrong in terms of future year bids.
I think that may be a court's pressure for future years on transfers from the prison service.
Okay, no problem at all. No, I appreciate we're in January monitoring rather than future year, so absolutely no problem with that one. The final one then is this perhaps has already been covered, and apologies if it has. The 4.7 million available for reallocation internally. What business areas would that be reallocated to?
Okay, so I do have that. Just bear with me 2 seconds. Paper's not much better, Rachel.
At least you can load it and it's not telling you that it's 3 days ago.
So yeah, sorry. So where we're allocating that funding is we're giving a bulk of that. The 2 million is going towards LSA. As I said, we've explained the fact that there's been an increase in the demand for legal aid. We're also allocating some funding to dilapidation costs for NIPB. There's a little bit of money towards that legacy case that I mentioned that's with the police. There are elements going to state pathology around some salaries and consultancy that they require. There's some funding going towards some of our staff pressures that we have internally, and there is also 700,000 going towards legacy related compensation costs within the department. So that's sort of a broad overview of where those are going.
Thank you so much. That's me, Chair.
Thank you, Rachel. Can I just check, Sinead, had you another question? No, okay. Doug.
Sorry, Chair, no.
Sorry, Sinead.
Sorry, apologies. I thought it was me.
No.
Hands down.
Have you a question to ask, Sinead?
No, Chair. No, thank you.
That's okay. Thank you. Doug, thank you.
Yeah, thank you, Chair. Just very briefly, if I can, what's the 3.3 million that is required for PSNI protocol costs that you're bidding for, please?
So that is to fund the 308 officers that's needed for the full year. So that's the element. They needed 15.5 million, from the protocol. 9.8 million was met. And there was another 2 million was then provided, and then we had the pressure of 3.7 million, of which we were able to reallocate some funding internally, so this comes down to the 3.3. So it's for those 308 police officers for the protocol.
Okay, good enough. Thank you.
Thanks, Doug. Just to conclude with Deborah, a couple of things. And this will test my vision, because I'm trying to read this off the bid. So I have to think. I think the department makes these deliberately small so that you can't read them. Not that, as you know me, Deborah, I would never be a conspiracy theorist, but anyway. It's a bid in relation to safer communities, modern slavery and human trafficking. And it's a comment, and I'll probably have to get this further away from me so I can see it. A pressure of 300,000 has been identified in relation to support services for victims of modern slavery and human trafficking. This is a demand-led service, and the department has a statutory obligation to provide the support to victims. Is that a reflection that the demand on these services has, I understand, dramatically increased over the last number of months, and that bid is to reflect the organisations who are there to help those who have been the result of human trafficking?
I think that might have come up as part of our October monitoring round. As you say, it's demand-led. What I would need to go away and do, Chair, is actually find out for you what has been the increase in the demand compared to previously, and has it increased as a result of that?
That's
You're happy
okay.
I can get a bit more information on that?
That's okay. Thank you, Deborah. And then finally, what would be helpful as well, and I'd mentioned it earlier in relation to the issues in regards to the legacy piece, it would be helpful if we had some information on how the requirements for the legacy inquests have changed, and particularly, obviously, there's this one that has created a particular challenge. Just a general overview in relation to the funding profile that there has been of legacy and how that has been handled over the last period of time.
We'll get that to you, thank you.
Okay. Okay, can I thank you very much? And Deborah, it's good to see you again. And all the help you've been to us in the past. In a former life when I was in the Department of, as it was then, Social Development, but that has now long since gone and is now the Department of Communities. So thank you, and thank you to your colleagues as well for your time this afternoon. And there may be a couple of questions that we maybe haven't covered, but we'll forward those to you in written correspondence just for a follow-up.
That's great. Thank you very much, Chair. Thank you for your time.
Thank you very much. Okay, members, just to get your approval that we would submit any of the questions that haven't been covered to Deborah for answer from the department. Agreed? Agreed. And also to request, to get your agreement to request a copy of the January monitoring forms that are provided that they be provided to the committee within 7 days of their submission to the Department of Finance, and to ask the department to provide a written update on the outcome of the monitoring round and the details of the remaining budgetary pressures facing the department at the conclusion of the monitoring round. Great. Okay, members, thank you. And just so that we are clear, we will be coming back to the issue of the budget, and I would ask members to, over the next few weeks, to take a look at the budget proposal, because this will be a major issue for this committee, because there are real challenges in relation to it. So I think that there's a considerable amount of work that's ahead of us in relation to the budget proposals. Agenda item 6, with your indulgence, members, we'll try and work our way now through some of this other business which has to be concluded, is the SR on the Magistrates' Courts and County Courts Appeal Criminal Legal Aids Cost Amendment Rules Northern Ireland 2021, and you'll find that at pages 89 to 116 of the meeting pack. This statute rule will amend the Magistrates' Courts and County Courts Appeal Criminal Legal Aid Rules Northern Ireland 2009, which prescribe the remuneration payable to solicitors and counsel for the criminal legal aid in the Magistrates' Court cases and County Court appeals. There is a statutory requirement to review the rules at least every 3 years, and the purpose of the statutory rule is to give effect to the proposals arising from the second statutory review. The committee agreed at its meeting on the 21st of October 2021 that it was content with the proposal of the statutory rule, which is subject to negative resolution procedure. The Department has advised that there has been no change to the policy content since the SL1 was considered by the committee, and the Examiner of Statutory Rules has raised no concerns regarding the technical aspects of the statutory rule. And so, can I put it to the committee, is the committee content with the statutory rule, and I put the question that the Committee for Justice has considered SR 2021/311, the Magistrates' Court and County Court Appeals Criminal Legal Aid Courts Amendment Rules Northern Ireland 2021, and has no objection to the rule. Great. Thank you. Agenda item 7 in SL1, the County Courts Fee Amendment Order Northern Ireland 2021, and item 8, the SL1, the Magistrates' Courts Fees Amendment Order Northern Ireland 2021. We'll take these two agenda items together, and we'll find that information at pages 118 to 144 of today's meeting pack. In our meeting on the 21st of October, the committee considered the information from the Department of Justice and the proposals to make 2 statutory rules to prescribe fees for new licensing applications arising from the Licensing and Registration of Clubs Amendments Act 2021. The committee agreed to ask the Department of Justice for further information on a number of issues, including the details of the assessment undertaken by the Court Service, which concluded that £354 is an appropriate fee, whether the Department for Communities had provided a view on the proposed fees, and when the new fees will come into operation and how they will be communicated to stakeholders. The committee also wrote to the Department for Communities to ascertain what consideration was given to the fees and whether stakeholders and industry bodies were consulted or submitted comments on fees during the development of or passage of the bill. The committee considered the responses from the Department of Justice, Department for Communities at our meeting on the 18th of November and agreed to request clarification if stakeholders and those working in the industry were consulted specifically on the proposed fees. The Department has indicated that the Northern Ireland Courts and Tribunal Service did not carry out a specific consultation on the proposed fees, but an informal consultation took place. The Department has outlined the engagement between the Court Service, the Department of Communities and representative bodies on the new types of licensing applications in advance of the implementation of Part 1 of the Act, and no concerns were raised over the proposed fees. It is to seek the views of the members on whether you are content to note the two proposals of the statutory rules to prescribe the fees for new licensing applications arising from the Licensing and Registration of Clubs Amendments Act 2021 in view of the additional information provided, or whether you wish to submit any other views or comments that you require for further information or clarification. Thank you. Agenda item 9, update on the SL1, the Proceeds of Crime Act 2002, the application of the Police and Criminal Evidence Northern Ireland Order 1989, Amendment Number 2, Order Northern Ireland 2021. You'll find that information on pages 146 to 156. At the meeting on the 17th of June, the committee agreed that it was content with the proposal for a statutory rule, subject to the negative resolution procedure, to make 4 minor corrective amendments and add a new schedule to the Proceeds of Crime Act 2002, application of the Police and Criminal Evidence Northern Ireland Order 1989, Order Northern Ireland 2016. The rule will assist practitioners in the reading and application of the relevant articles of the 1989 Order and exercising relevant powers under POCA, including the new powers which are due to take effect on the 28th of June 2021, when the range of Northern Ireland provisions of the Criminal Finance Act 2017 commence. The Department is now advised that in drafting the rule, it has identified 2 further technical and minor corrections required in the 2016 order. The Department has provided the text of the proposed amendments, indicated that they address inaccuracies in the original drafting of its proposing, and that they should be included in the statutory rules. And just to seek the members' views that you're content with the proposal to include the 2 further amendments in the Proceeds of Crime Act 2002, application of Police and Criminal Evidence Northern Ireland Order 1989, Amendment Number 2, Order Northern Ireland 2021, or whether there is any further information or clarification that's required. Thank you. Item number 10, the Civil Legal Services Financial Amendment Regulation 2022 written paper. You'll find that information at page 158 to 163 of the meeting pack. The Department has written advising of its intention to consult on a proposal for a statutory rule which will be the subject to the negative resolution procedure to amend the Civil Legal Services Financial Regulation Northern Ireland 2015. The purpose of the statutory rule is to make it possible for the redress payments for victims and survivors of historical child abuse in care in Scotland who are now living in Northern Ireland to have their payments disregarded for the purposes of civil legal aid means testing. The Department intends to conduct a 4-week consultation on the proposed statutory rule to ensure that the regulations are enacted prior to the election period, and is to seek the views of members that you're content to note the intention of the Department. Gemma, you have a question?
Yeah, no, Chair, it's just a comment, and it's just basically to really welcome this, and I'm delighted to see it come before the committee. The sooner it's in place, the better, really. The state caused these victims and survivors harm, and whatever remuneration is paid out to them, it will never be enough, and it should certainly not be taken into account when accessing or assessing for legal aid purposes. So, obviously, we'll never be able to undo the hurt, but we need to make every effort to try and make life easier for those who suffered so much. So I just want to welcome it, Chair.
Thank you. So members are content to note the Department's intention to consult on the proposed statute rule to consider the matter further when the SL1 is available or whether there is any further information or comment that we require. Rachel?
Sorry, Chair. Just out of interest, and I suppose we can return to this, but just to, if we're not all together, say, whenever it does come in, the 1% projection. I just wonder where they got that from. I appreciate that is they're just using the projection, but in terms of that 1% of the current population, then would there not then be a sort of financial information on that? Perhaps that's coming later. But also, if there's any redress schemes and any future redress schemes then for victims and survivors in Northern Ireland, can these same provisions apply in Scotland?
Okay.
If they're living in Scotland?
Yes. Yep, okay, right. Well, we will ask the Department. Okay. Agreed?
Agreed.
Thank you. Thanks for that, Rachel. There's no other questions on that. Then we'll go to item agenda 11, the Domestic Abuse Offences Operational Date Update, and that's at pages 163 to 174 of the meeting pack. The Department has provided an update on the Domestic Abuse Offence Operational Date, which indicates that it is on track to meet the revised timescale of late February 2022. The Department will confirm the exact go-live date when the commencement order is brought forward in early February, and it will also provide an update on training and awareness in relation to the new offence in January of 2022. And just for us members to know, because this is something we probably come back to at some stage. Thank you. Agenda item 12, the Domestic Abuse Protection Notice and Order Update, page 176 to 275. The Department has provided an update on the progress of the work of domestic abuse protection notice orders. And the Department has outlined that a human rights assessment and rural impact assessment have been carried out. Potential data protection issues are being worked through. Meetings to determine how the notices and orders will work in practice and the type of data to be collected for reporting purposes have taken place, and the consideration is being given to the geographical locations for the two pilot schemes. Gemma?
Yeah, thank you, Chair. And I don't mean to be yapping, but I'm just concerned that the consultation has been closed for almost a year. And I know some progress has been made, and being from a rural area, I welcome the fact that they are taking rural needs into consideration and all, but it looks like we aren't really any closer to getting the pilot scheme set up. Whenever I was reading through the papers, I saw a pilot scheme and I went closer thinking, oh, this is the announcement, but it's not. It's just that they still haven't decided where to put the pilot scheme. So it's just really putting my concerns out there about the length of time this is taking. Yeah. I understand there is work to be done, but it's taken an awful long time.
Yep, and I think, as we said with the other element, we'll be returning to this in January. I think we should take a note that we will return to this and ask in January in relation to where they're at. But your point's well made in terms of pilot schemes. Thank you. Any other comment? Okay, thanks, members. Agenda item 13, the impact of Youth Justice Agency services. Find the information on pages 277 to 316. The Youth Justice Agency has produced a performance impact report covering 2020 to 2021 business year, which uses a mixture of quantitative data, user feedback through the regular service conducted on the agency's behalf by NISRA, statisticians and case studies. The agency will continue to develop its impact data further over time and intends to publish similar information next year. One of the purposes of the report is to raise awareness of the agency's work, and the Department has offered to facilitate meetings with Youth Justice Agency staff working in members' constituencies. So just to note the Youth Justice Agency Performance Impact Report for 2020-2021, unless there's any other further comment. Thank you. Agenda item 14, the draft strategic framework. Sorry,
Sorry, Chair, I just had a wee question on 13.
Yep, okay, apologies, Rachel, because I can't
Apologies,
see the
sorry,
screen.
just
Yep, go ahead.
very quickly, just on the performance impact report, I'm just wondering, does the Youth Justice Agency intend on looking at producing, say, inspection reports or anything, on follow-up on that? I'm aware that fairly recently there was a press statement and an investigation that highlighted problems in relation to the Lakewood Regional Secure Care Centre in my constituency in North Down. And there had been a number of reports done with RQIA, but it seems that RQIA reports aren't published. And I'm just wondering if the Youth Justice Agency are intending on looking at that in the future as part of, say, their performance impact reports, because the RQIA has oversight of Lakewood, but there's no reports in relation to children's services, unlike there is in adult services. And there was certainly things that had been brought up about confinement and staff members and so on, and major incidents. So just a bit of concerns there from Youth Justice and a point of view, and if we're not getting maybe the whole picture.
Yeah, okay. And I think the other thing too, we should go back to the Youth Justice Agency and get, because they've offered to facilitate the meetings with the Youth Justice Agency staff working in members of the Justice Committee's constituencies. I think at least if we had that information, then members could, in their own time, make that contact and have those conversations with that staff. So I think that will be useful for members to have. Thank you. And members, I can't see now if you've put your hand up, so you'll just have to shout, and then I will hopefully hear you. And I'll not take it that you're trying to disrupt the proceedings of the Justice Committee. Agenda item 14 is a draft strategic framework for the Youth Justice update, and it's a written paper. And that's at pages 318 to 425 of the meeting pack, and also at pages 60 and 65 of the table papers, where you will have a copy of the action plan. And the committee considered the Department's response to the findings and the recommendation of the Northern Ireland Audit Office follow-up report on managing children who offend, published in December 2020, in March and July of this year. The Department has now provided a first draft of the strategic framework for youth justice and associated action plan, and intends to share it with the criminal justice partners and key stakeholders across the children's sectors for their views. The documents are based on evidence and best practice, as well as proposals developed by the criminal justice partners and other key departmental stakeholders during the scoping study on the youth justice system completed in 2016. Once the stakeholder reviews have been received and considered, the strategic framework will be finalised for ministerial approval with a view to publication in the spring. A written briefing will be provided to the committee prior to publication. And just to check with members, any other information that members require, or do we wish to submit any views or comments at this stage?
Chair, can I comment?
Go ahead, Gemma. No, go ahead.
Sorry.
Okay, Gemma.
Yeah, thanks, Chair. Sorry, Rachel. It's just, Chair, the Youth Justice Review recommended raising the minimum age of criminal responsibility and giving equal protection to children by repealing the defence of reasonable chastisement for parents smacking children. These are really huge recommendations and would represent a real shift in how we treat children and young people. And it's hugely welcome that the minimum age of criminal responsibility is referenced in the draft strategic framework. However, it is a regret that we've missed the opportunity to legislate in the Justice Bill for this. I think giving children equal protection is hugely important, and it's crucial. It's a crucial children's rights issue, and I think we should legislate for it at the earliest opportunity, Chair.
Thanks, Gemma. Yes, Rachel.
Thank you. I have to concur completely with Gemma's comments there. But in terms of the just with the Youth Justice Draft Strategic Framework, I have a number of questions here, Chair, and I'll rattle through them, but I'm happy to send them over to Christine if that would be assistance. But yes, the child-friendly questionnaire and plans to roll this out. This is, there's a number of times that this has happened, and when the department have been, consulting. But what does that look like, and how are they planning on rolling that out? The full list of recommendations and actions remaining outstanding from the Youth Justice Review, and I know a number of us were at Tracing the Review launch a couple of weeks ago. There's a number of those that are still outstanding, so I'd like to get sort of a department's response to that. And then there's a quite, sort of getting clarity on the proposed Children's Justice Bill. Is that addition to consolidating the relevant legislation, or is that a whole new bill that's being discussed? So I'm happy to send these over, Chair, if that would be of assistance.
Yep, that's okay. That would be helpful. Thank you, Gemma. I just want to check. Anybody else in relation?
Yes. Chair,
okay.
Sinead,
okay.
Sinead
Yep.
Chair, can I just also go on record? I heard Gemma's words and I wholly concur, and particularly in the most recent context of some of the really horrific news that I can barely stomach to even read or watch, and the whole chastisement and what's considered reasonable and not reasonable. It's a conversation that has to be had, because it's the thin edge of a very, very dirty topic that really needs to be confronted. And I think we all need to get comfortable at being able to bring that topic to the table and find the first legislative vehicle we can to start dealing with this, because it just can't continue. It can't continue unchallenged. And I've certainly heard the representations via this committee, but I've heard the stories outside this committee, and it's not something I can park away. I think we really need to deal with it. Thank you, Chair.
Yep, thank you, Sinead. Obviously, it's a very sensitive issue at the minute, but I think that people should not make the mistake that there are parents out there who use reasonable chastisement and would never go to the lengths that we saw played out. And there are other social factors that played into those particular cases which need to be equally considered. And I have to say, from my point of view, and I don't speak as chair, I speak now as a member of this committee, either the age of criminal consent or the issue of reasonable chastisement are something that we would give support to. But and I want to be very clear in this, and I've said it before in this committee, and that is that there needs to be those that love and respect and place for our children. I speak as a father and I speak as a grandfather who loves his children dearly, but no one should equate my views on those issues with somehow that opens the door to the horrendous and barbaric stories that we have seen played out on national news over the last couple of weeks, because they have just been absolutely horrendous. Peter?
Chair.
Yep, Sinead?
Sorry, Chair. Chair, yes, thank you. Appreciate. Sorry for cutting over you there, Peter. Okay. But my point is, Chair, I hear your views. My point is, I don't think anybody's views should be an obstacle to us having this conversation. I think it's really important that we do. I think it's really important that we bring this into this place and really sit down and confront it, because nobody is suggesting, and I certainly wouldn't want to be on record to suggesting that a lot of loving parents may make the argument you make, Chair, but that's not to say that we don't have the conversation on how do we best protect all children.
Thank you. Peter?
I mean, just from that point of view, I'm very happy that at some stage that there's a further conversation. It's just, I suppose, to be honest, Chair, you kind of preempted in your individual capacity what I was going to say, and I think you just do need to be careful that in looking at these issues that we don't conflate the general issues on reasonable chastisement and even criminal responsibility with some of the really horrendous cases. And I think we've just got to be careful that we don't give the appearance, if you like, of presenting parents, for instance, who are in that position as in some way tied in with some of the really horrendous cases we've seen actually largely across the water, but can happen anywhere in relation to it. But I think, Chair, you made the point very well, but it's obviously a topic some stage will be coming back to, I think, in terms of that in greater detail, I suspect.
Thank you. Thank you, members, for your comments in relation to those matters. It brings us to item agenda 15, progress in the delivery of the recommendations of the reviews of support service for operational prison staff and retired staff. and it's an update. And you'll find that at pages 427 to 481 of the meeting pack. The Department has provided a further update in the progress to deliver the recommendations arising from the reviews of the support service for operational prison staff and retired staff. And in relation to services for serving staff, 14 actions have been achieved, 8 actions have been significantly progressed, and 2 actions are partially achieved, and 2 actions have been held pending the outcome of other related work. In relation to retired staff, it is envisaged that a self-referral service to the Police Retraining and Rehabilitation Trust will take place early in 2022, and the PRRT is currently recruiting additional clinical psychologists to provide the service, and information sessions will take place in the new year with organisations that represent and support retired prison staff. And just for members to note, unless there is any other comment to make.
Chair, can I just ask, I note that they're due to be meeting today, also the report will be meeting with management staff and trade unions, and I just would like an update on the meeting, particularly a view from the trade unions, if that's possible.
Okay, that's fine. Thank you, Gemma. Item 16, call for views on the new domestic and sexual abuse strategy and a new equality safety strategy, new equal safe strategy, a strategy to tackle violence against women and girls. You'll find that at pages 483 to 647. The work is underway to develop a new domestic and sexual abuse strategy and strategy to tackle violence against women and girls. Given the close linkages, combined call for views to help inform the develop, both the strategies will be launched in January of 2022. The Department has set out 5 thematic work streams for the domestic and sexual abuse strategy, the objectives of the strategy to tackle violence against women and girls, and has provided the call for views document. The public survey and the victim survey will be used. The responses will be analysed and the evidence summary reports produced for each strategy. And it's for members to note the engagement to be undertaken on the 2 new strategies through the call for views, or whether there's any other further information or clarification that members require. Thank you. Agenda item 17, committee work programme. And you'll find that at page 649 to 656 of meeting pack, and the relevant papers on the committee forward work programme for January 22. The Department has provided a list of items of business it would like the committee to consider at its meetings in January of 2022. The Department has also advised that it can provide a written update on progress on the joint secure juvenile care and justice campus as requested on the 20th of January. However, it will be in a position to provide a more fulsome report update at the meeting on the 17th of February if the committee is content with this approach. The main priority of the committee during January of next year will be to complete the committee stages of the Justice, Sexual Offences and Trafficking Victims Bill, which is due to end on the 28th of January. Given the tight time frame for the committee is asked to consider holding a meeting on the 6th of January 2022 to undertake its informal deliberations on the Justice Bill and the potential amendments. No other items would be scheduled on the agenda for this meeting apart from a briefing by the Bill Clerk. So it's to seek the opinion and views of the members to schedule the work items requested by the Department in January and to receive the update on the progress of the Joint Secure Juvenile Care and Justice Campus at a meeting on the 17th of February, and also your views to hold a committee meeting on Thursday the 6th of January at which the informal deliberations of the Justice, Sexual Offences and Trafficking Victims Bill and potential amendments will take place. Rachel?
Thanks, Chair. I'm just wondering, before the 6th of January, if there is a meeting scheduled, are we going to be able to have the departmental responses back to all the issues raised on the clauses by all of the groups and organisations that we've heard from so far?
I think that is probably an unknown, Rachel, and I think it's a valid point that we could end up in a situation where, and I'm not trying to influence the decision of the committee as to whether we should or shouldn't have the meeting on the 6th of January. But it's whether or not we have all those responses back that gives us the wholesome picture. And I think, Christian, you would probably would concur with that.
Yeah, well, I mean, we'll send the table down to them tonight or tomorrow morning. But I suppose they have covered a lot of the issues during the oral evidence sessions anyway. I'm not sure that we will get much different responses when they reply in writing to those. And we've also asked them to make themselves available for the 6th of January if the committee meetings to go ahead, so that they can also be there to answer any further questions or provide clarification. So I suppose the answer is, I don't know, Rachel, but I think they have covered in the oral evidence sessions quite a number of the issues, or Brian has put the department's position on the record in quite a number of the areas where there are proposals for changes. So I think...
No, I appreciate that. I just think there's obviously been today was a very, a interesting session, and there was lots covered there as well. And I appreciate just from also, it is coming up, it's the end of it's going into recess now at the end of this week, and people are entitled to their time off. Is this going to create additional workload for both the department and also staff as well, because everybody needs a break. Everybody has been working been working extremely hard this year, and I'm not talking about ourselves, I'm talking about staffing. So I would be mindful that if the committee wants to have a meeting on the 6th, but is this going to be putting undue pressure on workloads over what is supposed to be time off to recoup before what can only be described as will be insane next year for everybody? So just those couple of things. But if it has to be on the 6th, that's fine. But I'm mindful it is recess, and it is the time for staff to be off, and rightfully off.
I mean, I think if the meetings to go ahead, the pack won't go out to the Tuesday, because Monday is actually the bank holiday related to New Year, so staff won't be back until the Tuesday. And yes, some staff may have wanted Tuesday off, but if we have to run the meeting, at least some of us will be in to put the pack together. I think the issue for really the committee is working backwards, because the report has to be signed off on the 27th of January. So the latest you can do your formal clause by clause is the 20th of January, really. Otherwise, it's running really, really tight to get the report finalised and out and then agreed. And then if you work back, I think the main issue will be if there are amendments and the committee decides it wants to take forward amendments, getting those drafted and signed off by the committee and agreed and all the rest of it. That takes a bit of time, because the bill clerks have to have time to be able to prepare them and then bring them to committee. So when you work it back, if we don't meet until the 13th, you've got a week to decide your position on all the clauses in the bill, all the potential amendments, what it is you want to do, and get them drafted and signed off, really, which is just not going to be possible, I wouldn't think.
Chair, I think taking up the points that have been raised there, I appreciate it does create some levels of difficulties for staff. However, I think the problem, given both the importance of the issue of the legislation, but also the fact that there isn't, unfortunately, at the back end of this, if I can put it that way, there's no real elasticity on that to move. If it was a situation where this wasn't sort of end of mandate and this was just another January, if I can put it that way, and there was the opportunity for a little bit of extension to make sure things are better, I think we'd be in a slightly different situation. But I suspect we don't really have much alternative other than to have that additional scheduled meeting on the 6th of January.
And I suppose the other issue for us is as to whether or not do we, by not having it on the 6th, put more pressure on the staff trying to meet the deadline in terms of A, the report, and B, everything being completed by the 28th of January. So, and I do value very much, and our staff, particularly in the Justice Committee, have been under a considerable degree of pressure, given the number of bills that we have to deal with, and given the particular size of this bill, even though it's a reduced bill from what previously it would have been if it had been a miscellaneous provisions bill. So while I would prefer that we weren't going to have to do what we are, it looks like we're going to have to go for the 6th. But I think that is on the caveat that we will have to be very focused around what it is we decide to do. And yes, there is a risk that we may not have all the information back from the department in relation to what we have maybe asked for of them today. But I think generally Brian has given us a general course of direction as to where the department wants to or doesn't want to go in relation to the Justice Bill.
Jared, also just on maybe the slightly more smaller point of the two, but also seems sensible that given the fact that by the sound of things we won't have the full information on the 20th of January, but there seemed to be an indication it would be the 17th of February, but also then to ensure that we have that focus on the legislation. I think the suggestion that we get a full briefing on the, in terms of the issue on the 17th of February seems to also to be sort of compatible, if you like, with the other actions that we're taking.
Yeah. Okay, so our members agreed on those 2 points. We'll have the briefing in February in relation to the Joint Secure Juvenile Care and Justice Campus, and then we will have a Justice Committee meeting on the 6th of January, specifically in relation to the informal deliberations on the Justice Bill. Agreed?
Yeah, Chair, can I just come in there? I agree with the meeting in February, that's fine, and I agree with the meeting on the 6th of January, if needs must, but I would be a lot more comfortable if the department could give their written responses before Christmas. And I don't want to put any pressure on any staff, but this is legislation. It's not just a policy that we're deliberating. And as I don't want to put pressure on staff, and I have no problem with the meeting on the 6th. But I would just be a lot more comfortable if we could have their written responses sooner rather than later. Thanks.
Thank you. Okay, members, that brings us to item 18, correspondence. There are 5 items of correspondence, pages 661 to 981 of the meeting pack, and 4 items at pages 66 to 116 of the table pack. I draw your attention just to 2 items in the meeting pack and 3 items in the table pack, and then members will have an opportunity to comment on any other items of correspondence. Item 18.2 at page 661 to 668 of today's papers is correspondence from the department outlining its response to the findings of Sir Jenny report on how the justice system treats females in conflict with the law. The department sees the new justice-wide strategy to support women and girls in contact with the justice system as the most appropriate vehicle to deliver the recommendations. This work is in development, and once the associated action plans have been developed, it will be shared with the committee and Sir Jenny. The Youth Justice Agency has produced its own action plan for relevant recommendations, and a copy of this has been provided. So it's just to seek the agreement of members to request information on the timescale for producing the new strategy and action plan, and also clarification as to why the timescale in the Youth Justice Action Plan for each action are 12 months rather than 6 months, which was recommended by Sir Jenny. Agreed?
Agreed.
Item 18.6 is correspondence. You'll find that on page 980 to 981 from Dr. David Lowe, Senior Research Fellow at the Law School, Leeds Beckett University, requests a meeting with the committee to discuss a proposal for a bespoke version of a prevent strategy, which is a pre-criminal safeguarding strategy to help those who are vulnerable from being drawn into terrorism and hate crime currently operating in Britain, to reduce the hate crime and sectarianism in Northern Ireland. Department officials are due to attend the committee at its meeting on the 20th of February to provide an update on the progress of the delivery of the recommendations of the review of the hate crime legislation and a draft consultation document. And is to seek the views of members of whether you wish to hold an informal online meeting with Dr. Lowe to discuss his proposals, or whether it would be preferable to request further information in writing before considering the request for a meeting. And I would suggest we do the latter, and then we would be in a better position to determine when we maybe could have an informal discussion with David Lowe. Agreed?
Yeah, Chair, can I come in on that just?
Yes, yep.
Yes, I agree. I do think that written briefing would be preferable. But I think we need to be careful around it, that the North, like, it's a society emerging out of conflict, and we have unique circumstances. So a blanket narrative around terrorism or sectarianism needs to be clearly defined and understood. You know, it's different to global. There's a difference between global and local dynamics. So just maybe that point needs to be made to David Lowe in advance of that.
Well, I suppose a bomb in Belfast is no different than a bomb in Birmingham. It is still the same devastating consequences. It loses, costs lives and causes huge destruction. So I think there are some similarities, because the terrorist, whether he is from Northern Ireland or from any other jurisdiction in the world, has the same intent, and that is unfortunately to cause devastation and to take life. So I think the written briefing, while there are sometimes mute points in terms of some differences, I think the general remit of those who fall within the category of terrorists and those who would carry out those such activities, it would be interesting to see what he has to say as a perspective. And there have been many people who have given us a perspective on our situation in Northern Ireland down through the years, and I'm sure David or Dr. Lowe will not be the last one to try and give us his opinion. Okay, thanks members for that. Item 18.7, pages 66 to 68 of the table pack, is correspondence from the Minister of Justice regarding the recent launch of the Northern Ireland Prison Service recruitment campaign for custody prison officers. The campaign will consist of a number of new initiatives, including a situational judgment test that applicants will have to take part in to progress to interview. Advertisement will also be placed across the 10 socio-economically deprived areas of Northern Ireland, and the Minister has asked that members highlight this campaign to their constituents and to their community. Just for noting of members. Item 18.8, pages 69 to 71 of the table pack, is correspondence from the Department of Justice on the legislative amendments to tighten restrictions on GHB, GBL and related compounds. The letter was received on Wednesday and has been provided for information. Given the date on which the restrictions are being introduced, it will be included in the pack for our meeting on the 13th of January to give members an opportunity to consider the details more fully. Then item 18.9, pages 72 to 76, is correspondence from the Department of Justice providing an update on the current position regarding the provisions of relationship and sexuality education. The committee considered a mid-year update on the Department's business plan 2021-22 at the meeting on the 30th of November and agreed to request an update from the Department on the work and the engagement with the Department of Education to deliver a consistent age-appropriate relationship and sexuality education and clarification on the current position in respect of the review of the minimum content order. The Department has advised that the Department of Education representatives have not provided a substantive update to the Gillen Education and Awareness Group on their proposed next steps with regard to this, and have suggested that the committee may wish to seek an update directly from the Minister of Education. Just to seek the request or agreement from the members that we request an update from the Minister of Education on this issue. Agreed?
I have no problem with that. I mean, that's
Peter?
maybe the current site interest I'm named in the letter in a different context. Just from a procedural point of view,
yes,
I have no problem with the suggestion. Do we have to refer this on then to the Committee of Education if it's?
I'll speak to the clerk and advise them that we're going to write, and then we copy them into the correspondence.
Just checking the protocol just in relation
thank
to
you. Item 18.10, pages 77 to 116, is the report of the Northern Ireland Chamber of Commerce and Industry on Brexit 1 year on. The Northern Ireland Chamber of Commerce of Industry has published the report the 14th of December, which sets out findings following a survey of local businesses who are currently exporting or aspiring to export in the near future to assess the impact of the new trading rules and the global challenges in international trade since Brexit. And just to note the report. Rachel?
Oh, sorry, Chair, I haven't got my hand raised.
Oh, okay, all right, thank you. That's all right, thank you.
First up
We're
for
just
everything.
checking. And just members, if you're content that the action sheet with the rest of the items of correspondence set out in the cover sheet is agreed.
Great.
Item 19, Chair's business. You'll be glad to know that there's only two, I think. One is in reference to the PSNI correspondence regarding PSNI Violence and Intimidation Against Women and Girls stakeholder event. PSNI has now advised that it's postponing its planned online stakeholder event on its violence and intimidation against women and girls strategy from the 12th of January for several weeks to enable account to be taken of the national framework from the National Police Chief Councils, which is expected soon. The relevant correspondence can be found at page 983 of the meeting pack. And just to advise members that the event is likely to take place later in January or maybe even into February, and the details of the date will be provided in due course. And item 2 is correspondence from the Chief Executive of NIACRO. The Chief Executive of NIACRO has written expressing her thanks for the letter sent regarding her imminent retirement. The relevant correspondence can be found at page 984 of the meeting pack. That brings us to agenda item 20, any other business. Just to inform members that there are a number of e-cards have been received from various criminal justice organisations, and if any member wants to see them, if they contact the clerk, they can be provided. And just to conclude with the date and time of the next meeting, and that is the Justice Committee will take place on Thursday the 6th of January 2021 at 2 p.m. in room 30 in Parliament Buildings. And can I take this opportunity to say a word of thanks and appreciation to our staff, wish them and the members of the committee a very happy and peaceful Christmas, and I trust a prosperous 2022. We have many challenges and many issues to face, but I trust that collectively together, working as a committee, will continue to work our way through those difficulties. But I want to personally thank you for your help since I've taken over as chair. It's been a bit of a roller coaster for me, but I really appreciate your help and assistance, and thank you to Christine and to her staff, and wish you all a blessed and a peaceful Christmas. Thank you.
Hear, hear.
Thank you.
This is the Northern Ireland